All right, the Courts of Justice Committee will come to order. We've got a heavy docket, and we've got to finish by 11 today. So we're going to try and roll through some of these bills. So first of all, let's take roll.
Mr. Chair, you have a quorum.
All right. First, we have Senator Reeves, 1738. That bill is going to go by for the day without objection. That one is going to be taken up on Wednesday. Also, we've got two quick bills that came out of here 15-0 last year. Same committee, same panel. Senator Peake's expungement bill, Senator McDougal's expungement bill. Senator Peake's deals with alcohol offenses only. Senator McDougal's deals with marijuana as well for juveniles. I believe that we need to amend Senator Peake's so that it has a $150 fee to eliminate the fiscal impact. First of all, is there a motion? All right, it's been moved and seconded to make that amendment. All in favor of that amendment signify by saying aye. Aye. All opposed, that amendment is made. Is there a motion on Senate Bill 1037? Still needs to see it. Report and re-refer to the Committee on Finance. It's been moved and seconded. Roll is open. Senate Bill 1080, Senator McDougal's expungement bill, same form, is passed out of here unanimously and passed the Senate unanimously last year. Is there a motion on that bill? So moved. All right. It's been moved and seconded that that bill be reported and re-referred to the Committee on Finance. All right. So with that, we have Senator Cosgrove signed up.
Thank you, Mr. Chairman. You're going to like this one. This is really simple.
I like all your bills.
Well, I'd like to think that was true, but no. But this one really is pretty simple, Mr. Chairman. This is a Senate Bill 1655. The bill requires the Office of the Executive Secretary of the Supreme Court to develop a statewide evaluation plan and conduct ongoing evaluations of the efficacy of all of our special dockets that we've been creating in the Commonwealth. We have drug courts, we have veterans courts, we have mental health courts, or dockets, excuse me.
Senator Cosgrove?
Yes, sir.
Let's see what the Supreme Court has to say about this bill,
okay.
Whether they have any thoughts about it. Good morning.
Good morning, Mr. Chairman, members of the committee. Alyssa Padden with the Office of the Executive Secretary. Our office already collects this information pursuant to a rule of court, the Rule 1:25 relating to specialty dockets. So no issue that I'm aware of with reporting that information.
Okay, so you are okay with the bill as drafted?
Fine with it, yes.
Okay. Anybody have any concerns or opposition to the bill? All right, it's been moved and seconded that Senate Bill 1655 be reported.
Ayes 12-0.
You were prescient this morning. Very good.
Thank you, Mr. Chairman.
All right, Senator Dance.
Good morning. Thank you,
Good morning.
Mr. Chairman. I have two bills, and the first one is 1667.
All right.
Child support. Mr. Chairman, this bill would make payment plans for child support more realistic and accessible by reducing the down payment requirements and increasing the length of term for payment of delinquent child support obligations. This bill can be seen as part of a larger bipartisan effort to try to make payments of obligations that suspend driver's licenses more reasonable and thus available to more individuals. Is that the contention is that when individuals enter into a payment plan for child support, the suspension of his or her driver's license is removed, and which makes it very difficult for them to get to work and try to reduce this. So the plan is laid out that would still require them to meet it, give them a little bit more time to do it. And I have Mr. Randy Rollins, who would explain any detail more so as far as how that payment plan
Well,
would work.
let's hear from Mr. Rollins, and then let's hear from the, first of all, let me ask, are you aware of any opposition to the bill?
No,
Does the Family Law Coalition have any concerns about the bill?
no.
Mr. Chairman, we support it.
Okay. Senator Stewart? All right. Mr. Rollins?
Mr. Chairman and committee, Senator Dance has explained
Yeah, it
this. I
looks-
have an
looks-
example here which,
Everything looks pretty good, Mr.
Yeah.
Rollins.
Okay.
I'm not going to speak anymore from I know when to withdraw. Thank you, sir.
Kristen, this in good shape? All right. Anybody have any questions of the patron before I dismiss Mr. Rollins?
Yes, sir.
And Family Law Coalition have any input, or y'all okay as written? Okay. Bill is before us. All right, it's been moved and seconded. The bill be reported. I told you we'd be nice to you.
Thank you, Mr.
You
Chairman.
need to come back to the
11-1.
Courts Committee more often.
Okay. Now, my second bill, Senate Bill 1190. It creates the Uniform Partition of Heirs Property Act, which preserves the right of a co-tenant, and I had to figure out what that was, to sell his or her interest or inherited real estate while ensuring that the other co-tenants will have the necessary due process. What this is a bill that comes, it's one that has been done in about 11 states already, where they find a way to help people, minorities, really African Americans, maybe Native Americans, or just people that are not familiar with the law, and a person will buy part of their property and they're stuck with not knowing how to preserve the rest and might lose it. So this comes with requests that I have two people here that have come to support this. And I also have heard from a representative from gentleman in the legal field that says that there might be some resolution, but I'd like to let them present the information they have, and then I'll make a request.
Okay. We'll step right up. I think Senator Chapin had a similar bill last year, and maybe we didn't know that the Model Act was out there. So in any event, nice to see you this morning. Yes,
Good
sir.
morning. Marcus Comer. I'm here to give 3 points on this bill. One, it helps more than just African Americans and minorities. It will protect all families who have heir property. One of the main pieces that it will help is that it gives the owners right of first refusal. This will prevent developers from backdooring and forcing sales. And then if it does go to a sale, it would be forced to be sold at fair market value rather than an auction. This would help the families. And then the other point would be, if passed, this would allow families to use USDA funding to help with the legal cost.
Thank you.
Thank you.
Thank you, committee members and Chairman Obenchain, for your time. My name is Parker Agelasto. I'm the Executive Director for the Capital Region Land Conservancy. And in the land conservation community, we very much support the legislation for a Uniform Partition of Heirs Property Act. The Land Trust Alliance at the federal level has been supportive of this. And frankly, what it is helping us resolve is when you have a family farm and there are many heirs to that property, sometimes there needs to be some uniformity for members to share in the obligations and the liabilities with that property, and the hopes, really from our perspective, is that the land remains intact. If you think about a 100-acre farm, there's better economics to farming it than having it split into 5 20-acre plots. So we're really trying to resolve this. We have a property in Powhatan County that a property owner, one of the family members, has been trying to go through the court system for 6 years to try to resolve this, and it is very expensive if you don't have the Uniform Partition Act passed, so we ask for your support. I do understand that there's interest from the bar, particularly from those practicing with wills and estates, and if it is needed, we could work with them, but my father is a former wills and estates trust attorney, and he has pro bono done this heirs property for many African Americans who live in the Nelson County region and trying to help them. And if we have this legislation, we can help a whole lot more families. My last point that I will say, and this is something that I think we really need to understand, 100 years ago, African Americans in this country owned 15 million acres of land. Today, they own about 7.5 million acres. The African American community has lost half of their ownership of land in this country. I think if we pass this, we can help correct that.
Mr. Chairman, I have a question. What,
Senator Edwards.
the USDA funding, I heard that, what is that about?
So the new Farm Bill, the 2018 Farm Bill that was passed by Congress, now provides for funding specifically to pay for the legal cost to resolve heirs' property.
Okay.
But you must have the legislation of the Uniform Petition Act passed at the state level.
Mr. Chairman, I
Wait a
presume,
second. So the federal act specifically references the Uniform Act?
It does.
Okay.
So,
Senator Edwards, sorry.
I assume the USDA funding would be for farmland or rural land, not anything else. Okay.
Mr. Chair,
Senator Peterson.
let me ask you, there obviously is a common law remedy called partition.
Right.
Where if you have a piece of land and there's various owners competing, and there's, law dating back to William the Conqueror on that. How is this different than the common law?
So two things. A, it makes sure that first right of refusal is provided to a family member.
To any family member?
Somebody who is an owner, a co-tenant.
Someone who's actually on the land?
No, somebody who's a
co-tenant.
co-tenant on like the title.
Okay.
Air.
Correct, an heir. The second thing is it requires a fair market price be offered.
So,
Well, why wouldn't that be the case anyway? I mean, if I get some type of fiduciary appointed to sell the land, they're gonna get fair market value anyway. Everyone would have an interest in getting the
You
highest
can
price.
presume that, but I think what this does is prescribe the legislative process that would go to enacting what you're talking about is generally practiced.
so Senator Peterson,
That's my questions for now.
Yeah, Mr. Chairman?
There should be some others.
hang on.
Sure.
Senator Edwards.
Yeah, following up on that, I'm familiar with some of this. Fair market value, great. Suppose there's nobody who wants to buy it for fair market value? Then what?
Then it's not fair market value.
Look at the bill. Look at,
Well,
Mr.
tell me
Mr.
what it
Chair.
said, what does it say?
Senator Deeds.
I'd tell Senator Edwards, under the bill, if a co-tenant refuses the right of first refusal, the property goes to a partition and it's sold.
And here's
Simple as that.
Here's
how's it
the
different?
problem that I see with
Yes, it is.
Here's the problem that I see with the bill, and it goes to Senator Peterson's point about the existing remedy. Right now, we have a partition action that's available. You can either partition in kind or by sale. You partition in kind, the court divides up the property. The presumption is to partition in kind. That's the preference under our common law remedy. If it's partitioned by sale, it's a sale, and there's nothing that prevents a co-tenant from buying the remainder of the property. What this does is it creates an unrebuttable presumption that the fair market value adopted by the court is indeed the fair market value. It cannot be tested in the marketplace. So if the other owners of the property believe that the court undervalued the property or adopted a value less than the fair market value, it is a binding, unrebuttable presumption that that is the fair market value. It can't be tested in the marketplace. So that's the difference that I see between the current law and this. So let's move on, hear from other witnesses, and I do want to hear from the bar. Step right up.
Thank you, Mr. Chairman, Senators. My name is Pat Keller, Virginia Conservation Network. We are thankful for the patron and for the Black Family Land Trust and support this bill.
Thank you.
Mr. Chairman, members of the committee, Andrew Smith, Virginia Farm Bureau Federation. We weren't familiar with the concept how Senator Dance brought this forward, so we did want to express our appreciation that she's trying to work to settle some of these large estates to keep fragmentation of family farms. Thank you.
Thank you.
Mr. Chairman, Chris Nolan, I'm here in a personal capacity on behalf of the Uniform Law Commission. I'm one of the Virginia commissioners. This act was developed before I was appointed to the commission, although one of our own, Ellen Dyke, was a member of the drafting committee. And I would just offer up, if the desire is to work on this outside of session, then we'll definitely connect the ULC's resources with the patron to work on that further. And just for those of you who don't know, uniform law typically takes about 2.5 to 3 years, worked on by about 400 law professors, attorneys, judges that meet annually. And this is one of the products of that conference, so thank you.
Thank you. Senator Chafin.
Yes, sir.
How many states have adopted this model act?
I think it's 12 offhand, and I know that it's been introduced in 6 so far in the 2019 sessions across the
Follow-up
U.S.
question. Are any of those states in the southeast?
Mr. Chairman, I do not know the answer to that. I had it pulled up on my iPad momentarily ago, but I don't remember it, but I'd be happy to follow up afterwards.
Mr. Chairman, I have the answer to Senator Chafin's question. It's Iowa, New Mexico, Texas, South Carolina, Hawaii, Arkansas, Connecticut, Alabama, Montana, Georgia, and Nevada. So Georgia and Nevada.
Thank you.
All right.
Mr. Chairman, members of the committee, Jeff Palmore on behalf of the Virginia Bar Association. We spoke to the patron earlier this morning. I think the Wills Trust and Estate section of the bar is worried about moving a little too fast in this area and dealing with some of the issues that Senator Peterson raised, that there's hundreds of years of common law in this area, and trying to make sure that this legislation meshes with our common law. And our request would be that we have an opportunity through our legislative committee, working with the proponents of the legislation and with the Uniform Laws commissioners to work on this throughout the year so we can come back with a product that doesn't disrupt that common law.
And I want to say to the patron, I support in concept what you're doing, and I think that this is a good thing. It does concern me that the trust and estate section of the bar hadn't had an opportunity to work with this. This is a well-developed framework, but I think we need to make sure that it is consistent with the common law that Mr. Palmore mentioned. So the committee may have a different view, but my inclination is that we would be well advised to take a year and allow the bar to work on this and come back next year. I am generally very supportive of this, and I think it's a good idea.
Mr. Chairman, I would say if the temperature of this committee is that we should do a carryover of this bill and accept the support that's being offered to make sure we can put it in whatever order you all need to have it in that does not violate the Uniform Act. Because if we are not consistent with that, then we are not a part of it and cannot draw down the money as introduced in the Farm Act bill that was passed.
Senator Stewart.
Thank you, Mr. Chairman. And Senator Dance, I don't know if you can answer this or Jeff Palmore, but to what extent can you amend these provisions and stay in line with the Farm Bill? And I ask that question because, you know, I grew up and practiced law in a poor rural area, and I see exactly what they're talking about, where you've got 15 or 20 or 30 heirs, and they can't afford to do anything about it. So oftentimes it ends up going to tax sale, quite frankly, is what I have seen, because they just don't have any alternatives. So how much flexibility do you have to amend this and still stay in line so that you could potentially get the assistance from the Farm Bill?
Mr. Chairman, Senator Stewart, that's one of the issues that we hope to examine in more depth. And most of our uniform laws in Virginia have some unique Virginia aspects to them that don't put us out of conformity with the rest of the uniform laws. And so I think that's what we need to just make time, take time to
Mr. Chair.
examine.
Mr. Chairman,
Senator Stewart.
So have you all not looked at this up to this point? Are you just become aware of it?
So we became aware of it when the legislation was introduced, but have not had a chance.
When was that?
At the beginning.
At the
before
beginning of session. You know, I think the Wills Trust and Estates practitioners in the state have identified, and their request is to work on it for a little bit of time. But they haven't had a chance to get into the weeds on these issues just because of the schedule that they.
Well, have they identified any concerns up to this point?
I don't think they even saw this bill. I mean,
He just said they saw it when it was filed
Mr.
prior to
Chair.
session.
If I could.
Senator Deeds.
A more likely scenario than the tax sale that Senator Stewart talked about is 150 years, a farm belonged to African-American family for 100 years or more. 2 or 3 people living on the farm, farming it, paying taxes, working the land, and some heir in Detroit or Seattle sells his interest for a few bucks to a developer who then files a partition suit. The people that have been on the property for the last 100 years working it are put out. Now, it's a well-documented phenomenon that's occurred primarily in the Southeast because of former slave families that got land and it went through the generations. It's a very real problem that Senator Dan is raising.
Senator Peterson.
Let me just make one comment, because if you listen to this conversation, you would think this bill only applies to rural counties. This is going to apply statewide, okay? And it's going to take a concept called partition that we're all very familiar with and replace it with a statutory code, which is going to be long and relatively complicated. It's going to raise the transaction costs on all of these types of transactions. And there may be reasons to do that to preserve family farms, but every single family that descends property, that has property that descends through the family, is going to be impacted by this, okay? So I understand we all got stories, but this is a huge change in our trust and estates code.
Senator Peterson, you want to make a motion?
I'd make a motion we carry this over.
It needs to be passed by indefinitely, but the understanding would be we're coming back next year and looking at this.
Excuse me, I thought we addressed carryover bills at the beginning of this session that was
No.
carried over from last year in different committees. So this committee
Session-
doesn't do that?
session- There's no more session. This is
I
the
know.
second year.
Okay, gotcha.
All right. It's your motion to pass it by indefinitely. All right, is there a second? All right, it's been moved and seconded.
Did you see the movie Wish You Well?
Ayes 8, noes 5.
Senator Dance, I think you have a lot of allies on this committee, and I think we do want to see this next year. And,
I am going to make sure I talk to Mr. Paul more now to begin the work that he has
you.
committed to help us with. Thank you.
Senator Boysko. Senate Bill 1638.
Thank you so much, Mr. Chairman. Feeling a little froggy, so my voice is not its best today. Mr. Chairman, members of the committee, I have an amendment in the nature of a substitute, actually, which should be distributed to you.
All right, Senator Peterson moves, Senator Stewart seconds the adoption of substitute. All in favor signify by saying aye. Aye. All opposed. Substitutes before us. All right. Tell us what your substitute does.
Yes, sir. SB 1638 helps Virginia's local governments and local newspapers with publishing legal notices. Legal notices are required to be published in what are called newspapers of record, which must meet certain statutory requirements to ensure due process that the legal notices reach as many people as possible in a given locality or region. Current requirements to qualify as a newspaper of record sometimes leads to problematic or confusing situations for Virginia's localities and their residents. This issue originally came to me in 2016 by the town of Herndon, and the stakeholders have been working on this to find a resolution for the past 3 years, but we believe we found it with this substitute. Some localities in the Commonwealth have very few or very small newspapers, and some have none at all. The town of Herndon in my district lost its only newspaper, The Observer, back in 2010, and as a result, Herndon has to publish its legal notices in other nearby newspapers, often very expensive or not providing the general extensive news coverage in Herndon, and therefore they don't actually reach the an audience that they're trying to seek. As the newspaper industry continues to face these challenges, it's important that we clarify the code to fix and avoid these issues by updating the requirements to qualify as a newspaper of record. And we believe that we have found peace in the valley with this. This bill updates and clarifies the 5 conditions that newspapers must meet to qualify as newspapers of record in a specific locality, provides for ways for newspapers that do not meet certain conditions to petition the local circuit court to qualify, allows the elected governing body of a locality that does not have a newspaper of record to petition the circuit court to publish its legal notices in another printed medium, which grants that locality the flexibility it needs. It requires all newspapers that publish legal notices to post them on the newspaper's website, to post them on a statewide searchable website, which already exists, and the newspapers already are posting on. This was created and maintained by the Virginia Press Association. Requires them to keep an archive of 3 years' worth of back issues and to publish legal notices under a large identifying heading in a prominent location in the newspaper. All the legal notices, both on the newspaper and the website and the statewide database, must be accessible and free of charge to the public. These changes are supported by VACO, VML, the Virginia Press Association, and it helps both the newspapers and the localities, and I hope it's the pleasure of the body.
So does the Washington Post support this?
Well, the Virginia Press Association supports it, which is what's important to me. I have Amy
So
Perone.
Herndon doesn't want to pay the Washington Post rates.
Well, it's exorbitantly more expensive than the Observer
I
was.
think this violates the terms of the Amazon deal.
I don't know about that.
All right, let's hear from your witnesses.
Great.
Good morning, Senators. Bruce Potter. I'm publisher of a group of weekly newspapers and websites in Northern Virginia called Inside Nova. Also here representing the Virginia Press Association as a member of the Board of Directors. The VPA supports this legislation. We appreciate VML and VACO and Senator Boysko working with us on this bill. It really brings the legal and public notice standard in Virginia into the 21st century. It clarifies the existing law and ensures that the public will continue to be informed about the activities of local government. We appreciate your support.
Senator Norman.
A couple of years ago, I put in a piece of legislation that would allow for online advertising of notices, including what the senator's looking for, as well as foreclosure notices, with the continued compliance with publishing them at the courthouse. Every member of the press corps opposed it, and under some feigted explanation, but I realized it devolved down into a cost factor, an income situation. Are you willing to expand this bill to include foreclosure notices?
Sir, this includes all public notices and legal notices that are required to be published in a newspaper of record or a newspaper of general circulation. So that would include foreclosure notices, ABC licenses, legal notices required to be published by courts, et cetera.
So, Mr. Chairman, just so I am unequivocally clear that the Press Association will support online publishing of foreclosure notices.
Is that a question?
Yes,
That is a
that's a question.
We support the online publishing of public notices in conjunction with publishing in local newspapers. We believe that's the way to reach the maximum amount of people and ensure that the public is kept informed about what's going on in local government.
Thank you.
All right. Anybody else wish to speak in favor of the bill? Anybody have a contrary view?
Mr. Chairman.
Senator Stewart.
I just want to thank the senator for bringing this bill. You know, up to this point, it was unclear as to what newspaper qualified to publish it in, and I actually had a situation where there was a free newspaper who offered to publish the delinquent tax list for a county that I represent as a client, and there just was no clear answer. But they didn't have a subscription list. We didn't know who read the paper, if anybody, and so I think you've done a good job, and this actually clarifies the law and makes it much more workable.
You want to make a motion
I
there,
move to
Senator
report the
Stewart?
bill.
Thank you.
All right, is there a second? It's been moved and seconded the bill be reported. Any further discussion? Hearing none, the roll is open.
Ayes 14, no zero.
Great.
Thank you.
All right. 1645.
Yes, 1645, I also have an amendment in the nature of a substitute, and you should be getting a copy of that right now as well.
Senator Stewart moves, Senator Edwards seconds the adoption of substitute. All in favor signify by saying aye. Aye. All opposed? All right, substitute's before us. Tell us what it does.
Certainly. Mr. Chairman, members of the subcommittee, I've amended, SB 1645 directs the Secretary of Public Safety and Homeland Security to convene a work group with stakeholders, including the Department of Corrections, the Board of Corrections, and additional stakeholders, to develop a strategy for more detailed use of force incident reporting for law enforcement and correctional officers throughout the state. This bill was originally brought to me by the Loudoun County NAACP, who requested that we expand the reporting requirements for the Crime in Virginia annual report. But as I started to explore the feasibility of doing so, I learned that there are very complex challenges from privacy concerns, fiscal impact, and logistical challenges that needed to be addressed first. So I'm proposing here that we do a study and a work group to pull that together.
Secretary of Public Safety support the bill?
Because we just got the substitute this morning, he's not had a chance to study it, so he's told me that he would remain neutral until the policy folks have a chance to go through this.
We're directing them to develop a work group. I mean, I think it's pretty important for us to know.
I agree.
Can't this be done without a bill it's the Department of Corrections, State Police, and Board of Corrections. I'm sorry, the Secretary of Public Safety, Department of Corrections, State Police. State Police agree to the bill?
Again, I've had better conversations with the Sheriff's Department, who thought that this might be the right direction to go.
You mean the Sheriff's Association supports the bill?
They have said that they think that a work group might be the right direction.
Okay. Senator Stewart.
Thank you, Mr. Chairman. Senator Boysko, if the governor determines this is a good idea, couldn't he just direct these agencies or even suggest that they go ahead and do this?
I would be open to that, certainly. I was just trying to find a way to bring forward the bill in something that I felt was more reasonable for the Commonwealth to undertake instead of.
And I do think a work group is a lot more palatable than the framework that you originally put together. And maybe you can work with the Secretary of Public Safety, the State Police, and Department of Corrections, and I'm pretty darn sure that if the Secretary of Public Safety thinks it's a good idea, State Police and Board of Corrections will work pretty closely with them.
Okay.
All right. Anybody have any questions to the patron? Anybody have a motion?
I move to report.
Substitute motion.
All right, substitute motion.
I move to report and refer to the Finance Committee.
Do what? What's the question?
A report and
Need to go to
Chairman.
finance?
All right, substitute motion is to report and re-refer the bill to the Committee on Finance. Any discussion? Hearing none.
They'll kill it. They always do.
Yeah.
Thank you.
Ayes 9, noes 5.
Thank you so much for your time.
All right, thank you. Next, Senator Servell.
Yeah. No.
1757.
1757.
And there's a substitute for that.
All right. Senator Deeds moves, Senator Edwards seconds the adoption of the substitute. All in favor signify by saying aye. All opposed, the substitute is before us.
So, Mr. Chair, members of the committee, this bill just makes clear what kind of, or certain kinds of evidence can come in a child custody case. The original bill was much broader and it's been bouncing around for a few years. After talking with a bunch of different people at the Family Law Coalition, some other advocates, they wanted to scope it back for this year, study it over the summer, and maybe go broader next year, but do this narrow change this year. So basically what this bill does is, in a child custody case, right now, you're allowed to get into a history of family abuse. The code specifically says the court shall consider a history of family abuse. But if somebody is abusing a child who is not a child in common with the person in the case, the code isn't clear that that type of evidence can come in. So if there's abuse involving a different child in a different relationship, the code isn't clear that that type of evidence can come in a custody case because it's a different relationship. And this just makes it clear that that can come in.
All right. You aware, Senator Norman?
Senator Servell, it seems like a modest change on the amendment in the nature of substitute, but on line 32, I'm aware that family abuse is a statutorily defined term. Is child abuse a statutorily defined term?
It's a good question. Take me a second to figure it out, or maybe council knows. It would be in 16.2, 2228, I think, or somewhere around there. 16.1, right.
Well, and domestic abuse was a defined term in your
Here's my lifeline.
original bill.
It's a sad lifeline.
Yeah.
Mr. Chairman, Richard Garrett, Virginia Bar Association, Family Law Coalition, Commission on the Needs of Children. Child abuse is loosely defined in the in 62.3 with social services. However, it does reference the Department of Social Services Policy Manual, which defines all types of child abuse, physical abuse, mental abuse, and sexual abuse. So it's well defined within the juvenile courts. So the definition, having child abuse in there as it is, does reference in the code that the courts can look at.
Mr. Chairman.
Senator Norman.
I'm sorry, I'm functioning really slow this morning. Is child abuse a statutorily defined term without relying upon a manual?
Mr. Chairman,
Mr.
Senator
Benjamin.
Norman, we have not found a definition of child abuse, but what we have found is what was alluded to, 63.2-100 has a definition of abused or neglected child. And so the appropriate cross-reference on line 32 after child abuse would be to reference that statutory definition.
I would have
Thank
no
you.
problem with that.
Thank you, Mr. Benjamin. That's where I was going.
100.
Yeah, Mr. Chair.
Mr. Chairman,
Senator McDougal.
I'm moving a little slower than Senator Norman, but should we, should then it not be child abuse? Should it be abuse and neglect?
Abused or neglected child is the defined term. I said I had no objection if anybody want to make that amendment.
So I think it needs to be abused or neglected child as defined in 16, whatever that was.
Right. I'll make that amendment.
Kristen?
We're going to have to work on the wording to make it consistent with that line.
I think the other thing you could do, Mr. Chairman, is after child abuse, add in, as described in the definition of abused or neglected child, as that term is defined in 63.2-100.
Can we adopt that amendment in concept? All right. There's been a motion properly seconded to amend in accordance with Kristen's suggested language. All in favor, signify by saying aye. Aye. All opposed? All right.
Mr. Chairman, also on line 32, you'll see reference to sexual abuse. That is defined in the code at 18.2-67.10. And I don't think it would harm the bill to make that cross-reference.
Make it clear, yeah.
All right. Is there a motion to that effect? So moved. All right. It's been moved. Seconded? And seconded. All in favor, signify by saying aye. Aye. All opposed? All right. The bill's before us.
Second.
It's been moved and seconded. The bill be reported. Roll is open.
Ayes 14, no zero.
All right. Senator Servell, your next bill.
Thank you, Mr. Chairman. Next and last for this session, I think.
Senator Servell, those are words I never thought I'd hear from your lips. Next and last.
So the committee might remember this because it's identical to a governor's amendment that we rejected last year because I think you, Mr. Chairman, thought it was more appropriate for this to go through the legislative process than to be added by a governor's amendment on a bill where it wasn't vetted. And so it's here before you to be vetted. This bill just makes it clear that the courts have authority to make factual findings necessary in cases that children are abused, abandoned, or neglected for purposes of federal benefit. Juvenile courts specialize in making these kinds of factual findings, not just in custody cases, but also in abuse and neglect cases, child abuse cases, truancy cases, termination of parental rights cases, et cetera. And this doesn't, I think it just makes clear the court has the power to make these findings as opposed to just assuming it's in the court's plenary jurisdiction. And that's pretty much what the bill does. I think there's a couple people here to speak in favor of it.
All right. Be happy to hear from them.
Mr. Chair, committee members, Amy Woolard with Legal Aid Justice Center. We have clients whose services get interrupted all the time because there's a lack of clarity around this. Things like child-only TANF, the KIN-GAP program that you all approved last session, even down to school enrollment when there are custody considerations, having that finding of fact in the order to see where the child needs to be, how long the child is spending at a certain residence. This would greatly improve facilitating those arrangements. We support the bill.
Mr. Chairman, Richard Garrett, Virginia Bar Association, Commission on the Needs of Children.
Hang on 1 second. Senator Norman.
I have a question. Do we have any other statutory provision that requires a finding of fact to be articulated in the general district courts?
I believe in 20-124.3, at least in visitation cases, the court is required to articulate its factual findings to the parties verbally when it goes through the custody factors. It's required, the courts are required to, that's reversible error not to do that. I know that, and if Mr. Chairman, the Senator would note that this also just cross-references the fact that some state or federal benefits require certain factual findings to be made before children can obtain certain benefits. And so it just says that if you can show it's necessary to make those findings for purposes of obtaining that benefit, then the court has the power to do that, but it doesn't require them to make it.
Mr. Chairman.
Senator Norman.
I know as we try to improve on judicial demeanor that all judges are being encouraged to articulate to the party litigants the basis of their decisions so that when the party litigants leave, they have some understanding, even if they disagree. But does this bill contemplate that a written finding of facts would have to be made?
It doesn't mandate it has to be made, but it says the court has the power to make it if it's required for any state or federal benefit. So not all the time, but if a party requests it because it's necessary for some state or federal benefit, then the court would have to say yes or no. If the evidence supports it, obviously. There's some courts that have articulated that they don't believe the General Assembly has given them the authority to make that finding.
Mr. Chairman, does Mr. Benjamin have any wisdom to add on this?
Mr. Chairman, he is all out of wisdom on this particular bill.
So last year, I mean, I think that the issue that you brought was, frankly, the issue of special immigrant juvenile status as the federal benefit or the
one of them, yeah.
Right.
The one
and
that
this
prompted
still
this.
deals with that.
I think it would, somebody who does this kind of work more than me might say, well, there's other kinds of benefits. There's probably other benefits that it would tie to also, but.
But that's the issue that drives this, really.
That was the issue that resulted in the lack of clarity in the courts, when some courts said they didn't think the General Assembly had granted the authority for them to make such a finding.
So we're now basically, I mean, we're bootstrapping in federal law and asking the district courts, though, to make findings that may be necessary to satisfy a federal statute or regulation? I mean, it just seems, well, let's listen to the Family Law Coalition, see what they have to say.
Mr. Chairman, Richard Garrett, Virginia Bar Association, Commission on the Needs of Children. We support the bill. There are other federal funds that can come to children, such in foster care, that sort of thing, and the courts have to make certain findings of this. I will say on the issue that, Mr. Chairman, you raised as far as SIJS status, the federal law does not mandate that state courts get into immigration or make any immigration decisions. We're not asking that this General Assembly get involved in any of that debate. However, for a child who ends up in this country to be granted special immigration juvenile status, a state court has to make findings that they're either being abused or neglected or have been abandoned by their parents or in some place where they cannot be returned to their home country to family there because they can't find them. In other words, we have a child who is going to be, in all probability, in this country in foster care or in some other kind of care, and then they're allowed to get that type of status and, in all probability, other federal benefits that otherwise might be incurred by the Commonwealth. So the Commission is in support of this for that reason.
Senator Norman.
I don't know much about this area. What is a special immigration status, and does that include children that may be here illegally?
Well, any child who's here at this point to get special, it would be here without proper paperwork, or their paperwork has expired. In other words, a child comes on a tourist visa, and their parents abandon them and leave, or they're lost or abducted or something like that. So, you know, there are many reasons they would be there, but any child going into the immigration court would have some question about their immigration status. That's correct, Senator Norman.
All right.
Mr. Chairman, I just was talking with one of the stakeholders, and I don't think there'd be any harm to the bill to change the shall to may. Say the court may make a finding as opposed to shall. I don't think that would do any harm to the bill in terms of trying to achieve its purpose.
I'll move that amendment.
All right, that amendment has been moved and seconded. All in favor signify by saying aye. Aye. All opposed? All right, that amendment is made. All right, the bill is before us.
Move report.
Second.
All right, it's been moved and seconded that the bill be reported. I don't believe this needs to go to finance.
Ayes 7, no 6, abstentions 1.
Crept out of here.
Thank you, Mr. Chairman.
Congratulations.
See you guys next session.
All right. Have fun down the hall.
All right.
All right, next we have Senator Marsden.
Thank you, Mr. Chairman. Could we take up Senate Bill 1053?
All right, and is Senator Wagner's bill 1391 on?
Senate Bill 1391, he has requested that his bill be rolled into this bill.
Okay, so he's not planning on coming?
That's my understanding.
Okay, well, let's take up 1053.
Thank you, Mr. Chairman. This bill has been before this panel several times and has passed out of here last year 40-0. What it does is provide a parole option for individuals who were juveniles when sentenced, when certified to stand trial as an adult, transferred
This is
to the
Graham
adult
versus
court.
Florida.
One of the
Used to
four.
be. Yeah,
It was
and,
Roper, Graham,
we've heard this for
Miller, and Montgomery. And what this does is provide for a juvenile who is given a sentence that extends longer than 25 years, a
All right.
parole option.
And we've heard this for years. This is a familiar concept. Let me just point out that the Virginia was addressed in the Fourth Circuit in LeBlanc versus Mathena. The Fourth Circuit held that our geriatric parole did not satisfy Graham versus Florida However, it was appealed to the U.S. Supreme Court in Virginia versus LeBlanc, and the U.S. Supreme Court held that our geriatric parole does satisfy the parameters established by Graham. Am I mistaken?
Mr. Chairman, if I might, I think the ruling there was slightly different in that what they essentially said, and I would ask counsel for if I'm incorrect here, but they said that because this was came up on a habeas appeal as opposed to a direct appeal, that we had to pay greater deference to the ruling in Virginia, but that had this been on a direct appeal, there would be probably a different decision.
Well, I think, I mean, and it may be that counsel will disabuse me of this notion, but it looks to me like we've just got a policy choice.
That's correct.
Right now, under the precedent established by the Supreme Court, we're not operating under a mandate to change, but your bill establishes a framework for parole after 25 years if you are convicted as a juvenile.
That is correct, and it's 25 years of actual incarceration.
Right. So that's the policy consideration. So you have anybody who wishes to speak on the bill?
I don't know at this point in time that we've had certainly witnesses prior to this. It is a policy choice, and I think it's in keeping more with the Montgomery case in Louisiana than anything where the Supreme Court said that parole is a great option to deal with all of these cases.
Mr. Chairman,
I think there is a great diversity of view on approaches to parole. Senator Edwards.
You're dealing here with juveniles juveniles.
That's correct, Senator Edwards.
And that it's just, they're eligible for parole, doesn't mean they're going to get parole.
That is correct. And they must serve 25 years of incarceration from the time of their arrest.
All right. Bill is before us.
Mr. Chairman, I move that we roll Senator Wagner's 1391 into this bill, make him a chief co-patron, and report the bill.
All right. First, the motion is to roll Senate Bill 1391 into 1053 and to make Senators Marsden and Wagner a chief co-patrons. All in favor signify by saying aye. Aye. All opposed? That motion is adopted.
Now move to report.
Second.
All right. There's motion to report. Does this need to go to finance? Yep. No? Hang on.
Maybe not. Where's Stanley?
Ayes 7, no 7.
Bill fails to report.
Thank you, Mr. Chairman.
Thank you, Senator Marsden. Senator McClellan.
I have,
I'm sorry, you have another?
yes, Senate Bill 1659. There's a substitute. $16.59. Now, we also have similar bill, Senator Saslaw's juvenile trial of juveniles as adults. I don't know whether you all want these taken up together or.
Mine's been amended, the substitute I have, so I don't know if it's approximates it.
Charles, are these? Okay. All right, we'll take them up separately. We have a substitute. Is there a motion to adopt it?
So moved.
No?
So moved.
It's been moved and seconded. All in favor signify by saying aye. Aye. All opposed? All right, substitutes before us.
Thank you, Mr. Chairman. What this bill does is two things. It allows for prosecutors who are in a discretionary situation and who want to certify a case to the circuit court. It provides that they have the same information available to them as juvenile court judges do when they are certifying somebody under another section of the code. And it provides them with the time necessary to have this report written. It's the same information. There's 10 enumerated areas looking into the juvenile's background and record and amenability to for treatment. And again, what it does is does not take the discretion of the prosecutor away. It just gives them better information to make the decision. Roughly half of the cases that are certified to the adult courts are sent back and are given juvenile sentences. So what this is going to do is provide better information to prosecutors to make this decision and probably lead to fewer cases being referred to the circuit court and save some time, save some money. It just provides better information, provides the time frame to do that, and it does not take discretion away from prosecutors.
So your original bill would have prohibited trying anybody as an adult under the age of 16. This abandons that concept.
It abandoned that concept, yes, sir. This
All
is
right.
just the other half of the bill,
Right.
and I think it's good policy.
Well, let's hear from those who support your bill.
Good morning, Mr. Chairman and members of the committee. My name is Andy Block. I'm the director of the Virginia Department of Juvenile Justice. This is an agency bill. We support it. We worked with the Commonwealth Attorneys Association to land where we are today, and I urge that you pass it. Thank you.
Thank you, Mr. Block. Appreciate you being here.
Mr. Chairman, Amy Woolard with Legal Aid Justice Center. We support the bill. These are very serious decisions to transfer kids to circuit court. They face all kinds of risks in those situations, and this is really just giving prosecutors more information before they make those decisions.
All right, thank you.
Mr. Chairman, Richard Garrett, Virginia Bar Association, Commission on the Needs of Children. We support the bill as well as for the reasons stated.
Thank you.
Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of Commonwealth Attorneys, and we support the amendment in the nature of the substitute. It does give us more information. Right now, we're making these decisions in a very short time frame, and this gives us more time and more information to make these particular very important decisions.
All right, Senator Stewart, hang on, Mike.
Mike, my short life as a Commonwealth's attorney, I was a defense attorney prior up to that, knew most of those kids in the system because typically you don't have a kid who commits one of these offenses out of the blue that you want to try them as an adult. And just at least in smaller jurisdictions, it's been my experience that you kind of know the ones that are coming through and you know their situation. So why would we need to make this mandatory for everybody? Why couldn't this be, if they want it, and change the shall to a may on line 78?
Obviously, we're not opposed to that. I think, although I think that the patron might very well be opposed to that. This is limited only to those discretionary certifications.
I understand.
So, I mean, yeah.
But what if you know the family,
Right.
you know the kid, you have either, I mean, you've seen him coming through the system, you know all the situation, that child has to sit in juvenile detention or somewhere while you're waiting for this to be done.
Mr. Chairman, Senator Stewart, you're exactly right. It does delay that initial filing period because we're going to have to wait for that report to be done.
And what happens if they
Sure,
can't
sure.
get it done within 21 days and they've got to request an extension, and so the kid's sitting there and you're trying to figure out what to do?
Mr. Chairman, Senator Stewart, as far as that issue, as far as requesting an extension, that is contained in the bill. It is good cause. It's that final code section in the bill that says that shall be good cause to get it past 21 days. But it will require.
So you could.
It would require, it might very well require the child be
To sit in
in
juvenile
detention,
detention.
pre-trial or pre-hearing for a longer period of time.
Mr. Chairman, that gives me concern, and as I say, I've practiced in a small jurisdiction, and most of those kids I knew and their families, and I just don't see where this needs to be a mandate for everybody. So I would move that on line 78, after Commonwealth, the word shall be stricken and a may be put in there.
Mr. Chairman, if I might.
All right, Senator Marsden.
The concern I have with that, Senator Stewart, is that what that does is provide for sort of unequal justice and unequal information. That may be true in many, many cases. In other cases, people may use that may just to avoid time and trouble, and they're just not interested in looking into the case, and they're making an arbitrary kind of decision. This creates consistency across the Commonwealth that this report is given. This used to be the case back when I was a probation officer in the 70s. Everybody had to go through that study process. This is something the Commonwealth attorneys would like to have. And I think consistent justice like this is very important. And
Mr. Chairman.
Director Block, if.
Senator Stewart.
And I understand Senator Marsden. The Commonwealth's attorney's job is to do justice, not to get convictions. And this gives them the opportunity to request additional information if they want it, but it's not a mandate. My concern is, in some of these situations, you could have these kids sitting in these detention facilities, I don't know how long, waiting for a report that's not needed.
And that is correct, but there again, that time is calculated into any adult time they would get. So it is a question of they're staying in a juvenile facility, getting services, getting their educational needs met.
What if they're acquitted? What if they're acquitted? And then they had to spend all that time in there and they're acquitted? They don't have any time.
I think that very often what we're anticipating here is that this report will lead to fewer certifications. So I think in the net, this is going to benefit juveniles across the Commonwealth by giving Commonwealth attorneys more time and more information to make a measured decision. And I think this is I think keeping it at shall is an important aspect of the bill.
All right, Senator Stewart's made a motion to amend line 78, change shall to may. Is there a second? All right, that amendment
Mr.
has
Chairman.
been moved and seconded.
Mr. Chairman, I'd like to speak to that.
Senator Edwards.
This would gut the bill, because every Commonwealth attorney is just going to say, I don't have to do this, and it won't get done. It just guts the whole bill.
All right, Mr. Benjamin is dying to say something. I'm sorry. Steve, your thoughts about the amendment?
Yes, Mr. Chairman. If every Commonwealth attorney were as thoughtful as Senator Stewart, I would have no concern. My concern is where a Commonwealth attorney thinks that they know all they need to know in order to make this decision, but in fact, they're wrong.
Mr. Chairman.
Senator McDougal.
Mr. Chairman, in listening to Senator Stewart, we're focused entirely on the people that are going to be found guilty and are going to be sentenced for a period of time. We're not focusing at all on the people who might want to get to trial quickly because they think that the government doesn't have enough evidence, or the situations where the government has charged them with something more serious and there's something else out there that they can't hold them on and is going to use this process. So wouldn't we be wiser to let defense counsel file for this and have the court rule on it? So it's not, we don't leave the discretion to the Commonwealth, but we leave it to the defendant and their attorney and the judge to give this information. That would then put in some protections for that defendant who wants to get to trial quickly, and those who might feel very strongly that they want this information for the government to have.
Let's hear from Mr. Block and then we'll vote.
And Mr. Chairman, thank you. And I'm not going to speak to the merits of the proposed amendment, but I will say, Senator Stewart, with full appreciation for your concern, and Senator McDougal, for young people sitting in detention longer than necessary, the process as it currently stands takes so long by the time sentencing takes place in circuit court. And we have youth who are in detention centers for a year or 2 years that I think, on the one hand, spending 3 more weeks maybe is a negative. On the other hand, if it gives more opportunity to both develop the facts of the case and develop the background of the young person so that we're making the right decision, I think that would be time well spent. That one of the interesting things about the data on young people who are sentenced in circuit court is that some of them just end up getting probation, or some of them just end up getting jail time, or some of them even end up getting juvenile probation. And I suspect that some of that is due to the facts being developed further and coming out as time goes along, in addition to whatever mitigating or comprehensive story about the young person that comes out during the year or two that they're detained in a juvenile detention center. Right. So the point of the bill is just to give the Commonwealth attorneys more time, more information at the front end. Our view, of course, is that that would be time well spent, even considering that some young people might spend a few more weeks in detention. Thank you.
All right, thank you. Mike, the Commonwealth's attorneys support the amendment or not?
Mr. Chairman, to be perfectly fair, I mean, we gave our support to Senator Morrison as it was drafted. I understand Senator Stewart's concerns. We could certainly, you know, it's not,
All right.
it's a matter of integrity for our part.
I understand. All right, Steve?
To address, Mr. Chairman, to address Senator McDougal's question concerning defense interests, if you wanted on line 77, after the word subsection, you could provide for waiver by the juvenile's counsel or his parent or guardian. And so it would read that prior to giving written notice of his intent to proceed pursuant to this subsection, unless waived by counsel for the juvenile, that would permit some flexibility. But I would also add, as a defense attorney, that especially in cases where you're dealing with a child or any client who is innocent, the last thing you want to do is rush to trial. Those are the train wrecks I've seen.
All right, we have a motion to amend shall to may before us. All in favor of that amendment signify by saying aye. Aye. All opposed?
No.
Well, let's open a roll. Oh, I do?
Ayes 8, noes 6.
That amendment is made. The bill is before us as amended. It's been moved and seconded. The bill be reported as amended.
Thank you, Mr. President.
Ayes 14, no 0.
Senator McClellan, if you could allow us to take Senator Norman out of order. I think he has a logistical problem. $1369, one bill. Simple little bill. Senator Norman.
Thank you very much, Mr. Chairman. Senate Bill 1369, I have a
Senator Norman moves, Senator McDougal seconds the adoption of the substitute. All in favor signify by saying aye. Aye. All opposed, the substitute's before us.
Mr. Chairman, in the interest of full disclosure, this is generally an area of the law that I don't practice in, so I don't have a history of knowledge on it. But what this does is it deals with the Public Procurement Act, focusing on statute of limitations. And the real underlying question is what public body, with the exception of Department of Transportation, is affected by a statute of limitations. Currently, a state is not bound by a statute of limitations unless the statute expressly mentions the state by name. And what we are finding in the contract industry, that there are actually claims that are being brought pursuant to a contract 10, 15, 20 plus years after the fact. And one of the complicating factors is that you can have a general contract, and of course most general contractors are hiring subcontractors, and you have a flow down situation that creates some problems with a statute of limitations. What the substitute does is it attempts to mollify the objection somewhat of DGS by expanding the previously constricted statute of limitation. And the applicable language is on page 20 through 26 of page 1. And you can see that pretty clearly. No action may be brought by a public body for construction contract, and that includes a whole bunch of them, excluding the Department of Transportation, unless one is brought within 5 years after the completion of the work, or secondly, if it is a latent defect, which is a subject of some discussion, is brought within 5 years after it is in fact discovery. So that would extend it beyond the normal statutory provisions that are applicable to after discovered defects. And it says in any event no more than 10 years after completion of the work. And then the last provision is dealing with a warrant or guarantee under a construction contract, and it can't be an action cannot be brought more than 1 year after the expiration of that warranty or guarantee. It also has implications on the surety bonds, and I won't bore you with the litigation that this has gone through, but I have a witness here, and I appreciate you accommodating because he has to leave. But I would say one of the byproducts of this restricted statute of limitations as it now exists is that there is a lack of interest and participation by SWAM contractors because usually they are smaller and it potentially has an indefinite period of impact on them. And also contractors that are bidding it with this statute of limitations, the way it currently is, in essence, are driving the cost up on it. But we have a witness who wants to testify so that he can get back to making a living. Am I boring you?
We'd all love to do that. Thank you. Yes, sir.
Thank you, Senator. Mr. Chairman, my name is Scott Kowalski. I practice construction law pretty much exclusively for the past 20 years. I am on the state board for ABC, Associated Builders and Contractors, and that's the role I'm in here as well. I have been on the Board of Governors for the Virginia Bar Association and the State Bar Construction and Public Contracts Law sections for quite some time. The reason that this has come to the fore, and this is the second time this bill has been presented to the General Assembly, is a case that came in November of 2016, Hensel Phelps versus Thompson Masonry, highlighted for the industry the fact that the time does not run against the sovereign, but it does run against the subjects. That case was a project completed at Virginia Tech in approximately 1998. Litigation and claims ensued from that about 15 years after the project was completed. Hensel Phelps was left in something of a quandary. People and documents, memories had faded, and a $7 million claim was lodged against them by Virginia Tech. As a result of some mediation, a settlement of $3 million was reached. Hensel Phelps turned around to try to pass that down to the responsible contractors. The responsible contractors defended with the statute of limitations, which does run against the subjects. And the decision in November of 2016 created a bit of a storm in the construction law community. To the extent anyone else cares, we cared, and we started passing that information around to our clients, both through ABC and Associated General Contractors, and that information is going out.
So was that not an indemnity claim?
Their claim was in part an indemnity claim.
And doesn't indemnity, am I mistaken in my recollection, the indemnity statute of limitations starts to run upon payment?
Yes, Mr. Chairman, you're correct. However, the UNOS decision from the Virginia Supreme Court basically took the indemnity clause that Hensel Phelps had in all its subcontracts and invalidated it because it required an indemnity of the indemnity for its own negligence. And so the indemnity clause in the contract was stricken. The Supreme Court basically admonished Hensel Phelps and all general contractors, go fix your contracts so you can make sure to roll this unlimited time frame down to your subcontractors, which is what the resulting changes over the last 2 years to general contracts.
But the general thrust of your bill basically is that if the university had found this defect 25 years after the construction, they could sue a contractor 25 years later, whereas in private setting, they're limited to, what, 5 years?
5 years. 5 years.
5
yes.
years.
5 years is and the original version of the bill was 5 years. We've modified it somewhat. Senator Norman has added in a provision, or we've added in a provision that allows for a 5-year latent defect discovery period after the typical 5 years.
So this basically just asking the government to act like the rest of us.
I would say yes.
Okay.
Mr. Chairman. And other jurisdictions have done this. Mr. Gordon Dixon from AGC is going to do that in a little more detail, but almost every other jurisdiction that has done this has brought the state within the normal statute of limitations.
Well, let's hear, is anybody opposed to the bill? I can't imagine. Let's.
And if I can just add one quick thing, Mr. Chairman, that the idea of the statute of limitations is not to let someone get away with something that they haven't done. It's to protect. Okay.
All right. Thank
All
you.
right. Thank you.
let's frame the issue. Let's hear from why this is a bad idea.
Mr. Chairman, committee members, Joe D'Amico with the Department of General Services, and the administration does oppose the bill. And let me clarify, the administration opposes the bill as introduced. DGS has not seen the substitute. Heard today that it was presented. I will tell you that DGS was not aware of this issue until such time as the original bill was dropped back in early January. The section of the code that we are looking at is the section of the Virginia Public Procurement Act that was enacted in 1982 that has not been amended nor added to since that time. And DGS has not seen any impact to the competition that we have on our state contracts as a result to how contracts are procured today. I will also say that there's nothing that prohibits in the law today the negotiation of a time period for latent defects or patent defects or performance bonds in the Code of Virginia today.
So, but seriously, I mean, you all are the 800-pound gorilla. I mean, do you agree to those changes, modifications in your contract to limit the statute of limitations to 5 or?
Mr. Chairman, I'll tell you, I've never had a contractor bring that to my attention during negotiations in a contract.
Okay.
Today, the Commonwealth executes about $1 billion in construction annually. That's at the state and higher ed level. This bill passes, then state public bodies, institutions run the risk at some point in time of being responsible for a defect that it's a result of a contractor not performing based upon what they were contracted to deliver to the taxpayers of Virginia. And is it right for the taxpayers to have to pay twice for something that should have been delivered initially? So I think,
Joe, I mean, look around downtown Richmond. I mean, there are a lot of big buildings being built for private sector customers. I mean, don't they exercise diligence in trying to make sure that they got what they paid for? I mean, is there an epidemic problem that exists in the private sector that this somehow fixes for the government?
Mr. Chairman, I would say you're correct in your statement. Also, I'll say that not all construction projects are the same. You have a VDOT salt shed versus a public health laboratory, and when the public body and the contractor start looking at the risks for both, is there some negotiation that can occur in this area? And we agree that there can be. And also, we agree that we would like an opportunity to discuss this issue with the contractor community. We have not been provided that opportunity. And we feel as though the dollars that are involved here, when it comes to construction on the state side, and then if in fact this bill does pass, and a state body has to go back and cause a fix on our nickel, I'm going to be standing back before you and the Money Committee staff asking for that money when we're competing for new construction, renovation, maintenance reserve projects.
Now, and I know you haven't had a chance to see the substitute, but I mean, this doubles the limitation period that exists for private sector from 5 years to 10 years for the state. I mean, does that help ameliorate some of your concerns?
I would like an opportunity to review the entire substitute.
Mr. Chair. Mr. Chair.
Senator Peterson.
Let me just ask you a question, Joe, and I appreciate what you said, that the parties can negotiate a different statute of limitations as part of the contract, but then again, so could you. You could require them to have a warranty on their work, for example, which I assume that you do.
Yes, sir.
So you all have you have the ability to basically control your risk in this situation, wouldn't you say?
Mr. Chairman, that's an accurate statement. Yes,
All
sir.
right,
Senator
thanks.
Peterson.
20-year warranty. Right. All right. Right, now we've got, I
Mr.
guess,
Chairman,
the
if I could
issue
just make a
framed.
couple of points, is one, I know it was a slip of the tongue, VDOT is excluded from this bill. And number two, while I was not there, there are people here where this additional 5 years was discussed in a work group. So I appreciate that perhaps he hadn't seen the bill, but the concept is not foreign.
All right. Well, Anybody have any questions of the patron? All right, let's hear briefly from those who support the bill. And I think we get both sides.
Mr. Chairman, Gordon Dixon, I'm the CEO for the Associated General Contractors of Virginia. We represent about 90 prime contractors and about 200 subprime contractors on this issue. And so we are in support of this issue. It is my understanding that AGC did talk to DGS several years ago about this issue. So it is not a unique issue to them. And in fact, there was a piece of legislation that was introduced on the House side that was almost identical to this bill last year. It did not succeed, but it has been discussed. Our members are now becoming more selective in their public contracts. They are looking at these things. They're going to start building these consensus. If this continues the practice that it is, they will start building this price into their contracts going forward. Yes, sir.
Thank you, Gordon.
Thank you.
Next.
Good morning.
Good morning.
Mr. Chairman and other distinguished elected officials. My name is Al Bowers, and I'm trying my best to live to eternity. I don't know yet whether I'm a god or not, but I'm looking in the mirror every day and I don't see one. But I'm in the construction business, been in it since I was 6 years old. I just learned this year that there was a statute of limitation on contractors and now to subcontractors for an eternity. Means statute of limitations forever. I happen to know DGS. I know the folks there, they're good people. And I happen to know a lot of contractors who are trying to help our firms out. But if you have a law that says every project you sign is going to be for an eternity, then every price that we bid, we're going to have to tell our contractors to double it. Because we have to have some type of escrow in case there's a defect 30 years down the road. And just in case I don't make it to eternity, if my sons are running the business 40 years from now, they're going to have to cover a defect that I had an inspector to approve on a project. I just think we need to get some common ground here to make some common sense. And I'm not going to fly out of here. I'm going to try to walk out of here because I'm not a god. So I support this bill.
Thank you very much. All right, let's hear real quickly.
Yes.
If you'd register your support or opposition to the bill.
Sure. Nicole Riley with NFIB representing small business owners. I specifically have spoken to a member who, woman-owned construction company in Charlottesville, 80 years old, and they too have a lot of concerns with the fact that this would be in perpetuity. They can't sustain it. And so that we support the bill.
Thank you.
John Stankina, CEO, Marsh McLennan Agency, the insurance and surety side of the business. Since 2016, when this became available, the industry's been tracking it without a limitation to the bill. You're going to see what happened in Florida happen in Virginia, which is a restriction in the availability of coverage, expansion of cost, and the availability to small businesses to qualify for state projects is going to shrink substantially. So
thank you.
We support the bill.
Thank you. It's very helpful.
Mr. Chairman, members of the committee, very briefly, David Bailey, representing the Alliance for Construction Excellence. It's an alliance of subcontractors and American Subcontractors Association and others, and we realize that unless this bill passes, the subcontractors are really in jeopardy, and we support the bill.
Thank you. All right, anybody else in opposition to the bill or his support?
Matt Benka with the Virginia Contractor Procurement Alliance. I represent a lot of the mid-sized contractors, folks that typically can't keep this on their books forever. I mean, we're your local guys, so we encourage you to support this bill. It's very important to us.
All right, thank you. Let's hear from those in opposition to the bill. He doesn't take it personally, usually.
Mr. Chairman, Rich Flowosky, I'm with VCU. We oppose the bill as written. We believe that we will have to include more quality control folks on our part. We're talking about, I think, latent defects. I believe that we can chat about this, but latent defects building falls down, or is Virginia Tech? They just didn't put it together correctly. Is it my responsibility to do quality control on the project? If it is, in order to protect our interests, we'll have to increase our
Can't y'all
inspection
figure it
staff.
out by 10 years?
How long did it take for Virginia Tech to find the Hokie stone fall off?
I guess how long should it have taken?
Well, that's correct, which means
Okay.
it should have been better quality control. Thank you, sir.
All right, thank you.
Mr. Chairman, two last comments. One, I'm not aware of what the impact would be on the Commonwealth's bond rating. I'll tell you that the states that were presented to me that have a set statute of limitations of the 1410 have a lower bond rating than the Commonwealth. Again, not my area of expertise, but I think something that should be considered because of the dollars that are involved here. And then secondly, JLOG performed a study in December of 2016 on high-risk contracts. High-risk contracts included construction contracts because of the dollar values involved. They're very concerned about the policies that the Commonwealth has in place as it relates to the protections of public bodies and risk associated with these contracts. And an area of risk here that we have in putting a statute of limitations on these contracts is going to yet put public bodies in a position where they're subject to risk. Thank you, sir, for your time.
Ladies and gentlemen of the committee, you've got a sense, a line drawn in the sand as the bill moves forward. If you're so inclined, I am happy to talk to DGS on it. I don't know that the issue would change, but bond rating, I do see the fiscal impact statement doesn't make any reference to those
Well,
situations.
since this would need to go to Committee on Finance, if Secretary Lane has concerns about the impact upon the bond rating in the Commonwealth of Virginia, I assume he will have an opportunity to appear there and
That would be
express
fine,
those
sir. I'm sure
concerns.
we'll be treated very kindly. in
Mr.
finance.
Chairman.
Senator Norman, you have a motion?
I would move that the matter be reported and re-referred to the Committee on Finance.
Is there a second?
Second. And
It's been
Mr. Chairman,
moved and seconded.
Speaking to the bill, I think I'm a co-sponsor somewhere, but I have had some experience in this area. We know the king can do no wrong, so we have sovereign immunity. But this gives the king a sword going way, way back, and nobody else has this kind of power to go back that far and hold somebody liable. I think, and as the DJS indicated, they can put in the contract statutes of limitations basically, and I think we ought to do it by legislation. So I think this is a good bill. Thank
All
you,
right.
Mr.
Any
Chairman.
other discussion? Motion is to report and re-refer.
Ayes 13, no 0, abstentions 1.
All right, thank you very much. Senator McClellan, thank you for your patience.
You are welcome. I have Senate Bill 1687, which is a data collection bill that would require the Department of Criminal Justice Services to collect certain data relating to bail determinants for any person held in custody pending trial, pre-trial.
All right, we've got a substitute.
Yes.
It appears Senator Howell moves, Senator Stewart seconds the adoption of substitute. All in favor signify by saying aye. Aye. All opposed. Substitute's before us. Tell us what your substitute does.
The substitute, the main differences between the substitute and the underlying bill is to address some concerns that were raised by the bail bondsman. There are 3 minor changes, but
All right.
Do you want to know what those changes are, or you just
Yeah.
want me to go over the bill? Okay.
Why don't you go over the bill?
Okay. So right now, what we're trying to get at is right now we have data that shows that 46% of the people held in our local jails haven't been convicted of a crime yet. They're there pre-trial, and the number of people in jail pre-trial has increased 10% over the past 5 years between 2012 and 2017. As you know, when people are in jail pre-trial, they can lose their jobs, they can lose their homes. It can be a real hardship on them. And many defendants face an impossible choice between sitting in jail as their case moves through the system or paying their non-refundable fee to a bail bond company. This is not a bill to end bail. What this is a bill to do is collect data so we can figure out what's going on with the pretrial system, who is there, how long are they there, what are they there for, et cetera. I understand when the House bill was heard, there was some confusion between what this bill would do and a study that the Crime Commission is doing. And so to address that, what the Crime Commission study looked at a snapshot in time in October of 2017, looking at people who were detained at that time, but they did not look at all of the data that this bill would require, including the indigency status and the length of stay. And so this is a complement really to what the Crime Commission is doing. But to allow those to work in concert, we have added a delayed enactment clause and I believe a reenactment clause so that we can sort of do those two together.
I would like to hear from the Crime Commission because I know that the cohort that they are trying to analyze has turned into an enormous project, and that is probably going to continue. And Kristen's behind you. Let's hear a little bit about the Crime Commission's experience and what they see as the impact and the ability to accomplish what you're suggesting.
Okay.
Kristen?
Good morning, Mr. Chair, members of the committee. Kristen Howard, Director of the Crime Commission. Yes, the Crime Commission has been working on a pretrial data project over the past couple of years. It's taken us about 2 years to get to the point where we are now, and it is just that cohort of individuals from October 2017. We had to work with 8 different local and state agencies just to put together the cohort. So it's an enormous amount of information. And then aside from that, we are looking at a recommendation that we presented to Crime Commission members to look at statewide tracking of individuals. And that's a continued project so that we can link all of these systems together so that we can develop a plan to figure out how we can continue to do this type of data collection.
All right. All right, anybody have any questions of Kristen with the Crime Commission? All right, thank you. Sarah McClellan, you have people who'd like to speak in favor of this?
Yes, there's a coalition of several groups, and I think there are about 5 or 6 who are here to briefly touch on the bill.
Let's, okay, would be happy to hear briefly.
Mr. Chair, Adio Logan-Kade, Legal Director at Legal Aid Justice Center. We worked with a coalition of stakeholders who support SB 1687. Specifically, I wanted to address the issue you raised, Mr. Chair, about the Crime Commission study. To the extent that this bill does not seek to scrap the great work that the Crime Commission has done, instead to build off of that work and allow an agency of government, that being the Department of Criminal Justice Services that represents the executive branch, to begin to institutionalize for the state of Virginia the data capture practices that the Crime Commission has been studying these past 2 years. This is what this bill seeks to do. So it includes in both the delayed enactment and the second enactment clauses the ability and specifically the mandate for DCJS to work with the Crime Commission, to use the knowledge the Crime Commission has built up these last 2 years to start institutionalizing the data collection and capture that the Crime Commission has been studying, now making this a permanent part of the functions of state government in Virginia.
Thanks very much.
Mr. Chairman, members of the committee, my name is Ashley Diaz-Mejias, and I'm here on behalf of the Richmond Community Bail Fund just to briefly share a statement from one of our clients who could not be here this morning. She says, Good morning. My name is Camille Barnett. In late 2017, I was involved with Virginia's pretrial system. I'm here to ask you to vote in favor of SB 1687. When visiting Virginia in September of 2017, I was arrested on a first offense drug charge. I was in jail for a little more than 3.5 months without bond, and during that time, I lost my home and all of my belongings. I was given a bond hearing in January of 2018, and during this hearing, the judge granted me release on a secured bond set at $5,000. Despite my initial hopes for an opportunity of release going into the hearing, this was a devastating ruling. I could not afford to pay this bond. And to make matters worse, I could not find a bail bondsman willing to provide surety on my behalf because I was from out of state. I did not know where to turn. In April 2018, 8 months after my arrest, I got connected with the Richmond Community Bail Fund, which is a community-oriented charitable fund that posts bond for people free of charge. They worked to help secure my release, but without them, I do not know how long I would have spent in jail before my case was resolved. I am here to ask you to vote in favor of bringing greater transparency, accountability, and insight into Virginia's pretrial system so that experiences like mine can be accounted for. Thank you.
Yes, ma'am.
Good morning. My name is Kimba Smith Pradia, and I am a national advocate, and I'm in support of this bill.
Thank you.
I'm also here on behalf of Delta Sigma Theta Sorority Incorporated as part of their Delta Days at the General Assembly. And I think we can all agree, and lastly, but not least, I'm also a formerly incarcerated person that personally had to be detained, and during pretrial, I gave birth to my son while I was incarcerated. And so I think we could all agree that wealth or poverty should not be a factor in determining justice or in deciding whether an innocent person should be released pending trial. Hundreds and thousands of Virginians are held in jail, yet little is known about how many people across the Commonwealth have been subject to pretrial detention. People are in jail are cut off from important life functions like working, caring for their families, or accessing medication to maintain their mental or physical health. For anyone already struggling, being jailed pre-trial can mean sliding further into desperate circumstances. Studies show that unnecessary pretrial detention makes some people more likely to break the law once released. And I think we can all agree that we all want communities to be safe. And as also a former member of the Virginia Criminal Sentencing Committee, I know that that is a main topic that's been on the table as far as the state of Virginia needing to have transparency as we look at criminal justice reform. And I do know that I would like to see Virginia take a more active stance, because this pretrial detention and the area of mass incarceration in our nation is a big issue that other states are moving forward on. So thank you so very much.
Thank you for being here. If your remaining witnesses could step up and just briefly identify themselves and state their support for the bill. Thank you.
Good morning. My name is Erin Kemmerer. I am representing Southerners on New Ground, or SONG. We're an organization that works for racial and economic justice throughout the Southeast. And we express support for this bill. We think it's good for marginalized communities in Virginia.
Thank you.
Thank you.
Hello, my name is Ashna Khanna, and I'm the Legislative Director for the ACLU of Virginia. On behalf of all of our members across the Commonwealth, we'd really urge you to please support this bill. Thank
Okay.
you.
Thank you. All right. And I note that this has been requested by Finance if it should report. The Crime Commission is undertaking its, well, I guess, I'm sorry? Oh, well, let's hear from the Supreme Court.
Good morning, Dorian Dalton, Office of the Executive Secretary for the Supreme Court. Our Committee of Judges that reviews legislation recommends a position of oppose on this bill because of the significant financial impact to the courts. We are fine with supplying the data that we have, but not with adding additional fields to our case management system to capture this data. It would require significant reprogramming to all of our case management systems. Our case management systems are structured to only capture the data necessary to process the case. Additionally, our case management systems are charge-based, not defendant-based. Much of this data is not currently collected and would add to case processing time both in and out of court. Our district court clerk's offices are currently understaffed by 271 positions statewide. Requiring judges to write the reason for all bail determinations is particularly problematic in courts not of record, especially given the high volume of cases the district courts handle and the limited time available for each case.
Thank you. Senator Stewart.
Senator McClellan, correct me if I'm wrong, is all of this information available publicly now? What you're trying to do is establish some kind of big system that aggregates it and
That's
so you
exactly
can
right. That's
do
exactly
whatever?
right.
Do you have any idea how many people and how much something like this would cost?
Well, the fiscal impact statement that I saw said it was indeterminate, and that is part of why we added the delayed enactment and the reenactment. But as you mentioned, this data is currently available in a variety of different sources.
Right.
We are just looking to bring it all together so that we can bring transparency to pretrial detention and have the data necessary to determine, do we need to have reform, which many of us think we do, what should that reform look like, and have it be very thoughtful and data-based and
Well,
data-driven.
Let me point out that DCJS, which is participating in the Crime Commission study, has made an estimate that this would cost upwards of $1 million, I guess, annually to implement this. My suggestion, and it's just a suggestion, is that we wait and see what the Crime Commission's experience is. I mean, what they have been trying to do is to set up a framework to do what you're doing. And what they've found is similar to what the Supreme Court suggested, is that we don't have the systems in place, and they are working across multiple agencies to collect this information for just a cohort. And even that is an experience that is proving very difficult and challenging. But once they do that, I believe that they're going to have a framework and a system that will allow tracking of that cohort and experience that may permit this to be accomplished, and I think we can learn from their experience. So, it's just a suggestion that we maybe send your request to the Crime Commission and wait and hear from them before we undertake consideration of this next year, which I think is consistent with your delayed enactment.
As long as the commission looks at the additional data points that are included in my bill, as I understand their study right now, it doesn't include everything. It does not include data on the accused crimes, the cost and pretrial length of stay. And so I would hope that if that is the will of the committee, that we also ask them to include all of the data points that are covered in this bill and what they're looking at.
I don't know whether it's going to be possible to go back and add to the work that they've done, but they can certainly be asked to report on the additional data points that you have requested. Is there a motion?
Mr. Chairman, I move to report, there's as I understand, a delayed and a reenactment clause. Is that right?
No, a delayed enactment.
There's a delayed enactment, but did I hear you, because I can't see it in here, is there also a reenactment clause?
I thought there was, but let me double, there's not, okay.
I move to report.
Mr. Chairman.
Senator Reeves.
Substitute motion.
I'm sorry, was that a motion to what?
To report.
To report, is there a second?
Second.
All right, it's been moved and seconded to report and re-refer to finance, right? All right, Senator Reeves.
Substitute motion, Mr. Chairman, to PBI with a letter to the Crime Commission of Kristen to include those items that the senator was talking about.
Is there a second? All right, substitute motion is before us, and that is to pass the bill by indefinitely with a letter to the Crime Commission.
Ayes 10, noes 4.
Thank you, Mr. Chair.
Thank you. All right, Senator Eben.
Thank you. This is Senate Bill 1748, Mr. Chairman. This good bill came from the administration and has to do with banning assault weapons, weapons that have higher capacity magazines.
1748, sorry.
That's right, 1748, I should say, yeah. As I said, it bans the import, sale, or transfer of weapons equipped with magazines of 10 rounds or greater, making the crime a Class 1 misdemeanor, and basically prohibiting the possession or transportation of assault firearms. And it also prohibits the carrying of a shotgun equipped with more than 7 rounds in public. Currently, that applies only in some localities to assault and only to assault weapons. And this expands the ban to all Virginians, not just non-citizens.
Can I ask you a question? And
Sure.
maybe this is a question for counsel. So if I die and, you know, my Springfield semi-automatic handgun with an 11-round magazine goes with my personal property through my estate to my children, is that a transfer that would subject somebody to a Class 1 misdemeanor?
I would like, Mr. Benjamin, do you have a thought on that, or?
It would be a transfer.
Yeah, my intention.
I'm sorry, hang on, Adam.
Yes, Mr. Chairman, that would be a transfer.
All right, how about if I'm convicted of a crime that bars my possession of the firearm, if I give that Springfield semi-automatic handgun with an 11-round magazine to my brother in order to comply with the law, divesting myself, would that be a crime?
Yes, Mr. Chairman, that would be upon the transfer of the firearm, that would be a crime to the person receiving the firearm.
Okay.
If I could, Mr. Chairman, tell you what I'm getting at. I don't want people to have these weapons. I think it's in the interest of public safety. And what mechanism we use to remove those guns in that circumstance is one that can be worked out. But what I just want to say briefly to make a point is that assault weapons make any shooting much deadlier.
So, Adam, so you want those to be a criminal transfer?
I don't want it to be a criminal transfer. I want them to be removed in that circumstance.
Okay. So you want to ban them?
Yes, sir.
All right.
Yes.
So why not just criminalize the possession of them and ownership of them
Is the
now?
administration here? Nick, you want to come forward? No.
So you want to
No, I want where?
take people's firearms that they, law-abiding citizens and their families bought? Oh, these are, this doesn't, and let me ask you, I mean, this doesn't just cover assault weapons. This covers, pistols available in virtually every gun shop in Virginia.
Yeah, what we're calling high-capacity magazines, that's correct, sir. Yeah.
Okay.
And I could tell you why if you'd like to hear.
All right.
Okay. We know that assault weapons make shootings much deadlier. High-capacity magazines as well, particularly semi-automatics, are used in a higher share of firearm mass murders, up to 57% in total. And we know that when there was a federal and state assault weapon ban, that there were statistically significant and negative effects on mass shooting fatalities. Further, we know that bans work. We know that high-capacity semi-automatics have grown from between 33% to 112% as a share of crime guns since the expiration of the federal ban, a trend that has coincided with the recent growth in shootings nationwide. We also know that mass shootings, which guns would have been banned under the bill, include those that occurred at Parkland, Las Vegas, Texas church shooting, Newtown, Pulse nightclub in Orlando. We know that other legislatures including California, Connecticut, Hawaii, Maryland, Massachusetts, New Jersey, New York, and DC, have done this. California limits to 10 rounds. Connecticut, I've got the different rounds for different places. But hunters, bottom line is, if you're hunting, you don't need these. If there is an exemption, I believe, for if you're at a range that's already, oh, I'm sorry, that's for something else, for public. But we don't need these guns, and I don't think it interferes with hunting or self-defense. That's a policy question for the committee to decide whether or not they feel that high-capacity magazines are necessary, and if public safety is going to exist with them. I would contend not.
Okay. Thank you, Senator. You have those who wish to speak in favor of this bill?
Mr. Chairman, Brian Moran, Secretary of Public Safety and Homeland Security. We are very much in support of the legislation, and to try to address some of the previous questions, this mirrors the federal assault weapons ban previous years, so many of the questions with respect to implementation would have been addressed back in I think it was 1993 when it was passed by the federal government. So there is some.
Well, that was the assault weapon ban. That didn't deal with all guns. That didn't deal with handguns or wide variety of firearms that are out there that I don't think fall into that assault weapon category.
Well, Mr. Chairman, it does apply to anything over 10 rounds. So
I know this
but
does.
I think we have some experience with respect to the implementation of such a law.
Okay. Thank you, Mr. Secretary.
Mr. Chairman, I have a question.
Sarah
To
Edwards.
the Secretary, you've deleted in this bill under lines 116, carrying firearms in public areas prohibited. It should be unlawful for any person to carry, and you deleted loaded semi-automatic rifles, et cetera, and only put in there, left in there shotguns. Why is that?
Yeah, the public ban has to do with carrying any weapon that is more than, well, there are two pieces. One is banning the carrying of high capacity in public, and then the other is, more than 7 rounds in public. And the reason that's there is because we already were applying that ban in those urban areas. And this would just take it not just to the urban areas, but to all statewide.
You've deleted it.
No, if you read it the way it is now on line 121, it says here that it shall be unlawful on 117 for a person to carry and then when you go to 121, a magazine that will hold more than 7 rounds of the longest ammunition, and that makes it statewide.
So let me ask you this. So that would be a limitation on magazines that are carried in public that would have more than 7-round capacity?
That's correct, yeah, yeah.
I mean, just for shotguns?
Well,
or for any gun? So do you even know whether you can buy a magazine with fewer than 7-round capacity for most handguns that are out there?
Well, that's current, Mr. Chairman, the current law references the 7 rounds.
Do you understand? I don't really understand that.
That's new.
No, it's not. It's for public carry, and right now it's for urban areas by people who are not, I believe, by non-citizens. But this is just saying the ban that already exists in those localities, which are certain urban areas, would be for everyone.
Right.
And it would further say, yeah. Because there's A, B, and C in that section of 286.
So my question is, for the majority of handguns that are legally owned right now, can you even buy magazines that comply with that? Are they available in the marketplace? And I would posit that the answer to that is no.
Mr. Chairman.
So this is effectively a ban on possession of any firearm, which is okay. I just want to make sure that we make this clear.
Yeah, high capacity magazines.
Well, it's functionally a ban.
Mr. Chairman.
Well, that's no. Yeah, but now it moves it to 7.
Mr. Chairman.
Yeah.
Senator Stewart.
You are correct. And if you read this section from line 117 through 123, you have banned any type of weapon that has a magazine. I am not aware that you can even buy a magazine that's capable of holding less than 10 rounds. I guess you could create one. There could be one. But you would be banning anybody who wants to target shoot or whatever they're doing for self-defense, protection, anywhere. That's what this language does, without question.
Mr. Chairman, I hope you'll correct me if I'm wrong. I begin on line 117. The bill says that it shall be unlawful for any person to carry a shotgun with a magazine that will hold more than 7 rounds.
Well, if that's the case, all right.
It only applies to shotguns.
All right.
In that section, yeah. What I was trying to get at was people carrying around large guns in public in Virginia unless they're engaged in lawful hunting or lawful recreational shooting at an established shooting range.
Okay. Let's hear from, briefly from those who wish to speak in support.
Good morning, Mr. Chair. My name is Jamie Johnson. I am a member of Delta Sigma Theta Sorority Incorporated. Good morning. I'm here to let you know that we are in support of Senate Bill 1748, and that on a national level, we have a resolution enacting gun control laws to curb gun violence. Thank you.
Thank you for being here.
Good morning, Mr. Chairman, members of the committee. My name is Lori Haas. I'm with the Coalition and the Educational Fund to Stop Gun Violence. I'd just like to remind the committee that it was a semi-automatic Glock that shot and killed 32 students at Virginia Tech and wounded so many others, including my daughter. We support the bill. Thank you.
Thank you, Ms. Haas.
Mr. Chairman.
Senator McDougal.
Maybe this is, and I'm still a little sick this morning, so I'm not moving quite as quickly. But if I'm reading lines 133 through 149, it's unlawful for any person to carry semi-automatic rifle or pistol which holds more than 10 rounds. Exception to that is now law enforcement in the performance of their duties. So if a law enforcement, and I think I'm accurate, almost every law enforcement sidearm is in excess of 10 rounds. If they're going to and from work, they're in violation of the statute, the way it's written. So every department would have to.
Senator Stewart.
Senator McDougal makes an excellent point, and with the other concerns that I have, I'd move to pass the bill by indefinitely.
If I could just say one word, sir.
Hang on. Let's see if there's a second to the motion. All right, it's been moved and seconded to pass the bill by indefinitely. Briefly conclude.
Yeah, just on the public point, I wish this was a law on August 12th, 2017 in Charlottesville. We might have had a de-escalation of the situation in that park, in that area. So that's what I want to get at.
All right. Motion is to pass the bill by indefinitely. Roll is open.
Okay.
Ayes 806.
Thank you, Mr. Chairman.
Thank you, Senator. Senator Mason.
Good morning, Mr. Chairman. Senate Bill 1418. So for a number of years, we've hung a bunch of things on the registered sex offender registry that our database and our computer system can't do. Just this morning, the state police posted an RFP to get a computer system that can do a lot of the things we require that they can't do today. But one of the things we are trying to do is clear up when you have to re-register. And I beg your pardon, Mr. Chairman, I believe that we'd like to push the enactment clause out to July of 20 on this. Do you
Okay.
Mr. Chairman,
Sorry about that. I should have started there. I apologize.
Charles.
There is an amendment to the bill after line 98, which is the end of the bill. The amendment would read that the provisions of this act shall become effective on July 1, 2020.
All right. Senator Edwards moves. Senator Sasslaw seconds that amendment. All in favor signify by saying aye. Aye. All opposed? That amendment is adopted.
Thank you,
Sarah
Mr. Chairman.
Mason,
My apologies.
are you aware of any opposition? Does the state police support this?
They're all right with the moving the clause to July 2020?
Mr. Chairman, we can't vote on the state police. We have no position on the bill. We are perfectly ready to do that if we can get a year out to do it.
Right. The administration support this?
I don't know.
Have any opposition to this? And I don't know whether, is Ms. DeVoy here? And Ms. DeVoy, you have any concerns about this?
Very pleased if we could do this. It'll save the state over $600,000 a year in postage alone, and then folks can actually get into a location within a 2-week window and register when they actually have time to do it instead of waiting for the letter to show up, which sometimes does or does not show up.
All right. You aware of any opposition to the bill?
I'm not, sir.
Is this, Charles, you happy it's in good shape?
It's in good shape, Mr. Chairman.
All right.
And it does need to go to finance.
It does need to go to the Committee on Finance. Is there a motion? It's been moved and seconded. The bill will be reported and re-referred to the Committee on Finance. All in, roll is open. It's the easiest trip to Courts Committee ever.
I like following certain people in here, Mr. Chairman. Thank you.
All right. Those are all the non-committee patrons. Senator Sasslaw, you want to go? Huh? I don't know. Oh. Which is your longest bill?
Maybe none of them.
Let's do,
The juvenile trial as an adult, that thing's gone through a whole lot of changes. And the latest substitute, I think, may have.
we have a substitute.
Yeah.
Senator Sasslaw moves, Senator Stewart seconds the adoption of substitute. All in favor signify by saying aye. Aye. All opposed. Substitute is before
Mr. Chairman
us.
and members of the committee, the substitute has left everything in place as it currently is, except for a juvenile 14 or 15 years old who's charged with felony larceny. Everybody else, the law stays the same. And I think, at least they're not as upset with this version, the Commonwealth Attorneys Association. Okay.
Okay, Ms. Jenkins, good to see you this morning.
Good to see you, Mr. Chair. LaBravia Jenkins, Commonwealth's Attorney, City of Fredericksburg. The Commonwealth's Attorneys Association believes that the system of trying juveniles as adults is very workable as it stands. However, as Senator Sasslaw indicated, we are not as opposed to the bill as we were in the past. What this bill does is
Somewhere there's a compliment.
the specific ill that Senator Sasslaw was trying to eradicate was 14 and 15-year-olds being tried as adults for larcenies, and that is now what the bill does, so we do not oppose it.
You don't oppose it, or you don't oppose it as much?
We don't oppose it as much, is probably more accurate.
Okay. So this would remove your discretion.
Yes.
So what, and let me just ask you this. I mean, under what circumstances would you even consider prosecuting one of these juveniles as an adult for a larceny? I assume that it would have to be a pretty aggravated situation. Or a lesser offense of a deal in a more aggravated case?
Mr. Chair, personally, I would never consider transferring a 14 or 15-year-old for a grand larceny. That just isn't done under normal circumstances.
Right.
I think the history of this bill and how it developed was initially, without indicating larceny, it would have put a whole class of 14 and 15-year-olds who committed very serious crimes together. So under, I cannot cite to you, and maybe Senator Sasslaw can, of any 14 or 15-year-old being tried as an adult.
Any other questions of the patron or of the witness? Did you have others that want to speak? Yes or no?
Mr. Chairman, Richard Garrett, Virginia Bar Association, Commission on the Needs of Children. We support the bill.
Okay. We did adopt a substitute, didn't we? I think we did.
Yes, yeah.
Okay. Bill's before the committee. There is a motion properly supported to report the bill. Please open the roll.
Ayes 10, noes 4.
Okay. That one reports.
Okay. All right.
Senator Sasslaw looks surprised. What's your next bill, Senator Sasslaw?
This was brought to me by a constituent, apparently, and
What number is it?
I'm sorry, 1776.
Love it, man.
Famous year.
1776.
Great musical.
I remember that. Anyway, this was brought to me by a constituent who apparently had a pretty rough time during the marriage and subsequent to that in the process of trying to get divorced. And I'll be the first to admit this is not an area I'm familiar with and hopefully never will be. But and what this does is it erases totally the 1 year period from the date of the I guess the initial action. I called my daughter in San Francisco, who has built a law practice, she and another woman, a successful law practice in family law. California law is 6 months. And I asked her, I said, what are the pros and cons? She says, well, the longer it goes on, she says, count on it getting more acrimonious, count on it running up the bill for the parties involved. And it also is not a good situation for the parents. I mean, I offer up an amendment if anybody's interested, instead of eradicating the 12 months altogether, make it 6 months. I mean, in fairness, I've talked to Senator Norman and Senator Surville, and they probably weren't real keen on the bill, to be honest with you. But, I didn't talk about the 6 months. I mean, those of you who practice law have a lot more experience in this and what's doable, what's not. But it seems to me if you can get a court date within 6 months, then you shouldn't have to wait any longer. But
So is that what the effect of the stricken language does? You now can get that divorce in 6 months?
Well, no, it's done. You'd have to. I'd be willing to accept an amendment that instead of erasing the 12 months altogether, make it 6 months instead of 12.
Mr. Chairman.
So this just eliminates the ability to get it in a year.
Yeah.
That's what I didn't understand.
Well, having to wait a year.
That's what it eliminates, the waiting period. Right now, for a fault-based divorce, except for adultery, you've got to wait, you've got to be separated for a year before you're divorced. What this bill does is eliminate, you're talking about a no-fault divorce. This says it's fault-based divorce, unless it's adultery, you got to wait a year. This bill does away with that for cruelty or abandonment.
So what I'm saying is if 6 months is more plausible, I mean, I don't have a problem with that.
Mr. Chairman.
Senator Reese.
I just had a question, maybe for Mr. Benjamin, on how it all works. On line 32, it talks about an expiration of 1 year or 6 months, whichever is applicable. If we change it to 0 time, does that affect that line?
Mr. Chairman, Senator Reeves, subdivision 9, which you're referring to, is for a non-fault divorce. So it's 6 months if you have no fault-based grounds for divorce, if there are no children, and you have a property settlement agreement in place, and it's a year if there are children in place. But that lines 24 through 35 are just for a no-fault divorce, and they wouldn't apply to this change.
Like I said, I mean, if anybody wants to, I'll offer up an amendment. Instead of doing away with the 12 months altogether, make it 6 months.
Let's hear from the folks who are behind you. You're speaking in for or against?
I'm against.
All right, let's hear the fours first.
Thank you, Mr. Chairman, members of the committee. Valerie LaRue for Virginia Poverty Law Center, and we support this change. It would help attorneys who do divorces in the domestic violence space. Most of those clients have to choose no-fault grounds if they want to get divorced quickly from an abusive spouse, and they have to wait either 6 months or a year if they choose those. And so fault grounds, if they're hoping to end their marriage, sort of isn't open to them for that reason.
All right, thank you. Yes, sir.
Mr. Chairman, members of the committee, Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. Like Valerie said, VPLC said, on fault grounds, particularly in cases where there's family abuse or there is some threat of violence or imminent danger, we do support a shorter time frame in terms of making that separation and establishing divorce and reducing litigation and the costs associated with that. Thank you.
By the way, before you hear from the opposition, the woman that called me was involved in a violent type situation.
Okay, and those that oppose it?
Morning, Mr. Chairman. Richard Gary, Virginia Bar Association, Family Law Coalition. I want to step back for just a second and talk about what the unintended consequence of this is going to be. What this bill does is it carves out the 1-year waiting period now for all fault-based divorces. Right now, it's solely for adultery, where you don't have to wait a year. In reality, what happens is if you're in a bad situation, or if you're even in a tepidly bad situation, and you want to get into court and start getting some relief from the circuit court, you can file for a divorce mensa et thoro immediately. The second somebody leaves the house or the second you allege cruelty, you can get into the court, you can get pendente lite orders in place. The clock starts ticking for the 1 year, which ultimately allows you to get the final decree of divorce. What I foresee happening here is, yes, we have horrible situations where people are in abusive situations or such. They want to go ahead and move forward with the divorce. We already have protective orders. We can get into court now. But what's going to happen is a majority of litigants who may want to sit down and work out agreements are now going to be filing fault-based divorces. They're going to be litigating these things to try to get a divorce based upon fault in order to speed up the time. If you're going to change the waiting period, just change the waiting period for everybody. And frankly, we have not discussed as far as the coalition goes. I can only speak for the VBA as the president, and I don't want to go back and have Ms. Evely and the rest of the coalition run me out without studying changing the entire waiting period. But I'm betting the majority of the family law attorneys in the Commonwealth would not oppose decreasing the waiting period. We just haven't looked at it yet.
Well, Mr. Chair.
Senator Dietz.
Mr. Gary, wouldn't you say that this change would work well for people at the bottom of the socioeconomic strata who are in bad situations and want to get out as quick as they can, but wouldn't work so well for those people who are divorcing and have considerable assets that they have to work through?
I would say probably, but the situation is the folks with less assets, and frankly, in my practice, I deal with Norfolk Southern executives. I deal with sailors in the Navy. So I get both ends of the spectrum. And frankly, once we get into a road where you're having any contested issues, the costs start rising, and it gets more complicated. And when I can sit a client down and say, okay, you have these options in front of you, but it might be best to go ahead and get an agreement, get you guys separated out, get us out of court. And even though you're very angry, you're angry that he cheated on you, you're angry that she's been abusive to you in the relationship, let's move beyond it and get it settled.
But that, Mr. Gary.
Senator Dietz.
That raises an important issue. If she cheated on him, he can already get a divorce with less than 12 months. So the only carve out here is just the desertion and cruelty.
Theoretically, yes. I can tell you, I've only had, in my 22 years of practice, I've had many adultery cases. None of them have ever taken place earlier than the 1 year, with the exception of one. And in that case, the person who was alleging adultery insisted on getting a case set and tried. they did not meet their burden of proof, and that person now had absolutely no recourse at all with the court. All of the temporary orders were now invalidated, and that person is now there with absolutely nothing to fall back on. Currently, under the current law, if you file for a divorce of mensa et thoro, most practitioners are also filing in the alternative for a 1-year separation. If you don't meet your burden, you can fall back on something else. And I'm concerned that this may invalidate that, and potentially, you may get the fast court date, but you may find yourself in a situation where you no longer have court orders protecting you.
It's strung out litigation. Senator Obenchain.
I kind of think maybe we ought to come back and look at possibility of reducing it for everything or nothing. So I would move to pass the bill by indefinitely.
Motion properly seconded to pass the bill by indefinitely. Please open the roll. All right, Senator Sasslaw, you have any more?
Vote him no.
Pardon?
Vote.
Oh,
I voted you against passing. Is that okay?
13 noes, 1.
All right, Senator
man, that was a
Sasslaw.
close vote.
You have one more?
Yeah. A couple of years ago.
Senate Bill 1467.
Yeah. A few years ago,
Senator Sasslaw moves, substitute, seconded by Senator Howell. All in favor, signify by saying aye. Aye. All opposed.
If you remember, there was a deal worked out where in return for, I think it was for recognizing out-of-state permits, if somebody got a protective order against a spouse, they had to surrender if they had a gun, they had to surrender it within 24 hours. But the problem was that they could surrender it to anybody, including somebody else in the house. And I talked to various people, including the state police, other attorneys. They said that hasn't worked very well at all. So what this would do is you would have to, within 24 hours, to either turn it over to police, sell it back to a dealer, or someone that, or give it to someone where you would not have access to it. And with respect to, the police, within that judicial circuit, the chiefs of police would inform the courts who would be capable of accepting and, with respect to police departments, accepting and storing it. So, I mean, it seems to me that if a judge is willing to grant a protective order because there's some violence or fear of it, and that person ought not to have access to a gun.
All right.
That's the bill.
And we considered this bill, or at least a variant last year, and the one concern was that somebody complied with the law, got rid of their firearms in compliance with the requirements that are imposed here, but didn't do the paperwork, didn't certify.
Right.
They would be
Which they'd have to
subject,
do under this, yeah.
they would be subject to the same penalty
Right.
as somebody who didn't comply, didn't get rid of their firearms. Charles, is that addressed? I see the certification requirement is still in this substitute. I just haven't had a chance to process it.
We have changed that, Mr. Chairman, in the sense of the person who is prohibited from possessing the firearm, if he's caught with a firearm, is a Class 6 felony. But if a person fails to certify, it's a Class 1 misdemeanor. So there is a difference in the penalty.
48 hours. So it's still a Class 1 misdemeanor for not doing the paperwork.
Right, it's still a crime, it's still a Class 1 misdemeanor.
All right. Anybody have any questions of the patron? Senator Stewart.
Thank you, Mr. Chairman. Senator Sasslaw, even without this bill, based upon what was done heretofore, it's a Class 6 felony to possess a firearm after a protective order has been entered against you. Isn't that correct?
I believe it is, yeah.
So you're setting out an additional procedure, just sort of make sure they get rid of it.
To get to where they don't have access to the gun.
But already, they're guilty of Class 6 felony, which is
That's not
pretty
changed.
significant. Okay, thank you.
All right. Anybody have any other questions of the patron? This is a familiar bill to members of the committee. You have those who wish to register their support for the bill?
Mr. Chairman, Andrew Goddard, Virginia Centre for Public Safety. We support the bill, and we like the idea of making it clear how to get the gun and the person separated. Thank you.
Thank you.
Mr. Chairman, Valerie LaRue from Virginia Poverty Law Center. We also support this bill. Some police departments are already taking custody of people's guns under the current statute, so this would make it so that that remedy would be available to more people.
All right, thank you.
Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We support this bill as a measure to curb and prevent intimate partner homicide in Virginia, which is happening at incredible rates. And the law enforcement and localities who are not implementing the current statute appropriately or don't have a clear process for this, this provides a bit more clarity with regards to what a surrender and seizure process might look like, where storage might be, and so we support it for that reason.
Good morning, Mr. Chairman, members of the committee. Lori Haas with the Coalition and the Educational Fund to Stop Gun Violence. We support the bill. As mentioned by the speaker before me, law enforcement is seeking clarity on how to do this. They have the respondent to the protective order has 24 hours, but law enforcement is not quite clear on how to accept these firearms, when and where, and what it looks like. And outlining and describing in detail how they can do this and where they can do it, where the guns have to be stored and properly stored, would give law enforcement a lot more help to process these. Thank you.
Thank you, Ms. Haas.
Mr. Chairman, members of the committee, Nikki Zamosny, Assistant Secretary of Public Safety and Homeland Security, and for all the reasons already articulated, we support the bill.
Good morning, Ellen Volo on behalf of the Fairfax County Board of Supervisors. We also support the bill for reasons already stated. Thank you.
Right. Senator Stewart.
Mr. Chairman, if I may, I think I understand the law in this area, and as it currently is, it's a Class 6 felony to possess a firearm if a protective order, right, has been. But what concerns me is, well, frankly, anybody could do this anyway. They could give it to the police, and the police would hold it. They could sell it, or they could give it to somebody who's not barred from possessing it.
They could, but they're not required.
It does not, but they could do it. But when we layer another maze on people to comply with the law, we end up piling on charges, and that's what I don't like. I don't like to see you piling on charges for people.
You can lesser the
You either get rid of the gun or you don't. You're guilty of a Class 6 felony. So with that, I move the bill be passed by indefinitely.
Hold on.
Well, is there a second to that motion? It's been moved and seconded.
Can I ask some questions about this bill, or is that?
You go right ahead. You want to
right.
withdraw your motion for the time being? Let Senator Peterson.
And I apologize,
ask
I
his
actually
questions.
have some objective questions
Just
about
as
this
a
bill.
courtesy.
Yes, I'll withdraw my motion.
Thank you. There's been a federal law on felon in possession of firearms for, what, 50 years, 60 years? Definitely predates me. Do the feds have some type of statute where if you're convicted of a felony, you have to go through a process to turn over your firearms? I mean, maybe Mr. Benjamin knows that. I'm just not familiar with other statutes that prohibit firearm possession, how it actually works to get rid of the firearms.
No, Mr. Chairman. There's no federal provision regarding felons in possession who need to surrender their firearms. There was a case in the U.S. Supreme Court in 2015 where a felon did try to transfer a firearm to someone who was not prohibited from possessing a firearm. And the government took the position of, because he was convicted of a felony and could not possess it, he could not transfer it. But the U.S. Supreme Court said, oh, no, just because we're taking one of your property rights away,
Right.
possession, the felon still had the ability to transfer the firearm. And the court eventually approved the transfer of the firearm to someone who's not prohibited. So this kind of builds off of that in the sense of, if the person is prohibited, lays out the framework regarding the transfer of firearms.
Further question, Mr. Chair?
Senator Peterson.
Are there, and I know I'm familiar with the domestic, the injunction situation we're talking about, the protective order situation. Are there any other situations under state law where someone is prohibited from having a firearm and this would kind of be a safe harbor in order to turn their firearms over? Or is that the only?
Well, but this doesn't create a safe harbor. I mean, this
Well-
creates an additional charge.
No, I understand that, and I understand what you're saying, but what I'm saying is, if, let's say you're convicted or you're subject to this protective order, you gotta turn over your firearms, you're still in the house, you go to the clerk's office, you go to your cousin's house, you go over and you try and get rid of them so that you're not gonna be subject to a Class 6 felony, you know, in that window of time before you can get rid of them. I guess that's the question that I have.
Mr. Chairman, if I am to understand Senator Peterson's question, is this process available to other prohibitions for firearms?
Right.
And the answer is no, this is unique right now to just protective orders. So if you were a convicted felon, there is not an equivalent procedure.
All right, and last question, Mr. Chair. And
Senator
this is kind of
Peterson.
a half question, half comment. I think this could be a good bill in terms of the safe harbor. My concern is line 71, 72 says, exert any influence or control over the sold or transferred firearm. I'm not quite sure how you define that. I mean, if you say, you know, you gotta take the safety off before you operate it, I mean, is that any influence over it?
Mr. Chairman, and that language was from that Supreme Court case. It's Henderson v. United States in 2015, where the Supreme Court used that language of regarding firearms to be transferred from a felon in possession to a person not prohibited, saying that the firearm can be transferred to anyone who's not prohibited, who will not allow the person prohibited to exert any influence or control over the firearm.
Fair enough, thank you. That's all I have, thank you.
Senator Stewart.
Actually,
Mr. Chairman.
let me just say something there, Senator Stewart. This probably is more helpful to the guy because he'll probably be told you got to, you know, turn in the gun and file the paperwork. And if he's not told that, maybe he doesn't, and then he's definitely going to get hit with a Class 6 felony. I mean, you want to lessen the penalty for not filling out the paperwork promptly. That's up to you all. But it seems to me that to get yourself into a situation where a protective order has been issued against you, it's probably not the best of all situations. And we ought to do everything we can to get that gun out and tell the guy, you've got to do this. You've got to fill out and certify you've done it or else. I don't see why that's so onerous. I'm not feeling sorry for people who've had protective orders issued against them, I guess is what I'm saying.
Mr. Chairman,
Senator Stewart.
I understand, I don't disagree with you with much of what you said. I just think one Class 6 felony is enough. I don't know why we want to put two Class 6 felony on these people, so I would
Well, it'd be a
make the motion to
misdemeanor.
pass it
All right.
by indefinite.
All right, Senator Stewart moves, Senator Peake seconds motion to pass bill by indefinitely. The roll is open.
Ayes 8, no 6.
All right, bill's passed by indefinitely. Senator Chafin, you want to take your Senate Bill 1529? Try to. Yes. Are they here today? You may be able to. Senator, why don't we, while you get ready, Senator McDougal. And also, just a housekeeping measure pursuant to Senator Peterson's request, Senate Bill 1399, unless there's an objection, will go by for the day.
Mr.
Senator
Chairman,
McDougal,
could we do
1381?
1381. Mr. Chairman, this came from one of my local school superintendents in the Northern Neck. And Mr. Chairman, they had a situation where on Facebook, social media, I don't know that it was Facebook in particular, somebody made a threat to do bodily harm to an individual on the school. When they contacted us, because if that threat had been resulted in a charge, then there'd been no requirement to notify the school. Fortunately, in this case, the school got notified first, They called the sheriff's department. We looked at this. I thought it was covered. I think Charles thought it was covered originally, and the other statutes are, other particular offenses are covered, but not this one. So we added in, if it's a threat of bodily injury in writing to persons on school property, that the intake officer has to notify the school administration. Not earth-shaking, but important if it happens.
So an email saying, I'm going to kick your butt?
Mr. Chairman, if that results in a criminal offense, then yes.
Oh, if it results in a
Well,
criminal
Mr. Chairman, it
offense,
has to
okay.
be,
Gotcha.
if there's a juvenile intake
Gotcha.
officer involved, then that
Gotcha.
intake officer is the one is sitting in the role of the magistrate making that determination. What happened in this case was, particular case was the administration was notified. They reported it to Sheriff's Department, but it had been vice versa. The Sheriff's Department had gotten that information. There would have been no requirement to report it to the school.
Are you aware of any opposition to the bill?
Mr. Chairman, I'm not. I think when I talked to other people, they thought this was covered. We just learned it was not.
And I would just note that, you know, this is a Christmas tree that's growing, and we may want to think about whether we ought to impose a blanket requirement upon law enforcement to notify the schools, but that's not your bill, and it's not my suggestion for now, but we may want to consider that. Senator Stewart moves to report.
Second.
Does this need to go to finance? No?
No.
All right. The roll is open.
Ayes 14, no zero.
All right, Senate Bill 1385. This is a cleanup bill.
Yes, Mr. Chairman.
State police good with this?
I don't know that I'm willing to say that.
Okay, then go ahead.
But they might. But Judge, Ms. DeVoy talked to me, but this one in particular, just the lack of the ability to have a notification through the way we prescribed it in the code. And this clarifies that to make sure nobody's unwittingly getting convicted of a criminal offense for failure to register.
Yeah.
Certainly, we want them to register, but we don't want them to be convicted when they're trying to do the right thing because we haven't put the procedures in place.
And not that I want to beat up on anybody, but my understanding is that we had imposed a 30-minute requirement for people to notify the state police of change of address, and there's some debate or discussion about whether state police had a mechanism to accept notification within 30 minutes. And I know that there was a portal that they were asking for people to put their change of address in the comment section without generating any kind of a receipt. So I view this as a cleanup. State police have
Mr.
any
Chairman,
comment?
I do as well. We'll see what they say.
Mr. Chairman, Keenan Hook with the Department of State Police. We have no position on the bill. However, we did adopt a procedure that we rolled out in December of last year that enables offenders to click a link on our webpage and get directly to an email address where they can send an email and now get an email return receipt confirming that they did change their electronic, their email or other social media account address within that 30-minute period.
All right. Thank you. Anybody opposed this bill? Senator McDougal, you have a motion?
To report.
Second.
It's been moved and seconded the bill be reported. Roll is open.
Ayes 14, no zero.
All right.
Thank you, Mr. Chairman.
All right. Senator Chafin. I will if you go fast and just vote for my good bills. Senator Chafin.
Thank you, Mr. Chairman.
1529.
Yes, sir. That's a crime commission bill, and there are a number of offenses that were unanimously endorsed to place on the list. I think there are a total of 7, but I believe there's some interest in striking one of them.
I think there's a line amendment. This is part of the package that's addressing the $700,000 criminal record gap in the criminal records exchange.
Yes.
All right, Charles, you want to report the line amendment?
Yes, Mr. Chairman. On line 27, after the section 3.2, 6570, comma, after that comma, you'd be striking subsection B of section 29.1-238, and then strike the comma and the or and the section symbol after that.
All right, Senator Chapin moves that, second by Senator Stewart. All in favor signify by saying aye. Aye. All opposed? All right, Senator Chapin.
Yes, sir. So,
You aware of any opposition to this
I'm
bill?
not aware of any opposition.
Anybody in the room?
Mr. Chair, just-
Hang on. See, we'll do this in an orderly fashion. Anybody in the room have opposition to this? Senator Deeds.
Just for clarification, what did we just strike? 29.173.
Charles.
What is that?
Crime Commission. Colin, why don't you step up?
It's
It was DUI while voting.
watercraft.
Okay.
Colin Draver with the Crime Commission was DUI with watercraft.
All right. Is that okay?
Yeah.
All right. All right. Is there a second?
Second.
Senator, it's been moved and seconded the bill be reported and re-referred to finance. All right. All right, Senator Chapin, thank you very much. Senator Stewart?
Please, Mr. Chairman.
Which?
I only have one.
1441?
Yeah.
All
All I
right,
have is 1441.
without objection, 1441 will go by for the day. Senator Edwards? $13.07. Senator Edwards, you've got a Uniform Transfer to Minors Act at the request of the Virginia Bar Association,
That's
Trust
correct.
and Estate Section.
What this does, currently under the Uniform Transfers to Minors Act, the donor can designate at age 18, the juvenile, the individual obtains the property outright, or 21 to obtain the property outright. This change gives you the donor an option to transfer the property at age 25. We know because of studies about the brain, the judgment faculties don't really mature until 24, 25, which raises another question. But this, at least, if you realize, maybe I don't want to give to my child or something, or somebody, a child, then they should not have the property until they're 25.
John,
You can designate that.
I used to do trusts, and I considered this the knucklehead provision that would put in trust to prevent my knucklehead 21-year-old from blowing the entire estate.
That's right.
And
You can always do this by trust.
my only question is the last provision that basically is the anti-knucklehead or the knucklehead antidote. I mean, it seems to allow the 21-year-old to avoid my 25-year-old provision.
And, Mr.
Jeff?
Chairman, Jeff Palmer on behalf of the Bar Association, that provision is required to avoid a federal gift tax consequence. If you don't have that window at the age of 21, there's a negative gift tax
So
consequence.
basically, this allows me to designate age 25 unless my kids study the federal income tax code, in which event they can avoid it,
Or in this case, the state code, but yes.
or have a lawyer.
So, Mr. Chair.
Senator Peterson.
Basically, the kid would have to know 30 days before he turns 21 that he has the right to formally request this money, or if he misses that window, it just defaults over to 25. Correct. That's brilliant. Okay.
All right.
Keep them
Anybody,
stupid.
any opposition to this? Anybody have any other questions? Is there a motion on the bill?
Motion to report.
It's been moved and seconded the bill be reported. John, can I, actually, I've got one bill that needs to go to finance. Can I jump you because we've got to stop?
What's the number? 1621. Would you distribute the substitute, please? Senator McDougal moves and Senator Howell seconds the substitute. All in favor, please say aye. Aye. Opposed, no. The ayes have it.
Mr. Chairman, members of the committee, this is assault and battery against a family or household member bill. Right now, you have to have 2 prior convictions in order for the Class 6 felony to be applied. However, we've changed the law and essentially have allowed the first offense to be taken under advisement and basically doesn't count, potentially doesn't count. And if you have to have functionally 1 under advisement plus the 3 or the 3 in order to be subject to the Class 6 felony. This corrects what I think was probably has become a problem in that if somebody this basically provides that upon your second conviction you have the Class 6 felony applied, and that takes into consideration the 1 that was taken under advisement. And so you have to be convicted a second time, which basically is your 3rd offense, and applies the Class 6 felony.
Any questions of the patron?
Mr. Chair,
Senator Deeds.
the 3rd offense, if the judge in his discretion had granted you taking the first one under advisement. Doesn't
That's
happen
right.
all the time.
That's right.
Okay.
Right.
Mr. Chairman?
Senator McDougal.
That under advisement provision has not been around for 20 years. It's been around for less than that. So we're looking back into a period of time prior to that as well, correct?
Maybe so.
So, Mr. Chairman, you could have gotten a domestic assault against a sibling at some point in time 18 years ago, and then anything else, adult child or that would now put you in a felony 18 years later.
Mr. Chairman.
And if I could just, Senator Howell, Senator Obenshain, is that really changing anything? Isn't that the case now? You've just clarified the statute?
It's my understanding.
I don't think he's changed anything, Senator McDougal. He's just clarifying that you had to be convicted of an offense. In the second conviction, but I think that could happen under the law now. It's just really clarifying language. Senator Howell?
Well, that was my impression also, that it's just clarifying, but then how does it have a $15 million impact?
That's a darn good question.
I can't. 50,000.
Mine says 15 million.
Senator Peters.
Okay, maybe I'm thick, but if I look at line 15 or 13, it says, upon a conviction for assault and battery against a family member, in which such person been previously convicted, and we strike in 2 offenses and saying an offense that occurred within a period of 20 years of the instant offense. So if it's a previous conviction of an offense within 20 years and then another conviction, how are you getting to 3?
Because of the first one that's taken under advisement.
So you're just assuming that there was one taken under advisement?
That's usually the case.
It's almost always the case, Senator Peters. I'm not aware of people ones that aren't allowed to participate in that.
There was an old saying when I grew up about the word assume, but I know what you're doing here, but I just hate to sort of assume something.
Well,
especially within 20 years.
We talk about protecting victims of domestic violence. I mean, there was a firearms bill a little while ago that may or may not have provided some protection. This provides real protection for victims of domestic violence. So you really want to do something, this is an opportunity to do it. I mean, we can't, how many chances are you going to give somebody to beat up their spouse before we treat it as a felony?
Can I ask Senator Obenshain, is there anybody opposed to this? Is there a motion?
Except Senator, no, not.
There a motion? Anybody paying
Move
attention?
to report and re-refer to finance.
Second.
Motion properly seconded to report the bill and re-refer to Senate Finance. Please open the roll.
I'm just gonna abstain.
Is that all you have, Senator Obenshain?
I've got Senate Bill 1782, which is notary bill. Right now, and we have a substitute.
Senator McDougal moves and Senator House seconds the substitute be adopted. And all in favor, please say aye. Aye. Opposed, no. The ayes have it.
Mr. Chairman, members of the committee, this bill basically takes notaries and treats them the same as executors or administrators of estates. We count on notaries to make sure that there is integrity in public transactions. And frankly, there are many members of our community who place a much higher belief in the integrity of notaries because of the way that they're treated internationally. And there are many from Central America who, are used to notaries being lawyers, and they're not. And we count on them being honest and ensuring, to the extent possible, the integrity of many transactions. And right now, there are certain crimes involving moral turpitude that disqualify you from serving as an executor or an administrator of an estate, irrespective of whether your rights have been restored.
And this just would
Conforms
disqualify
that.
them if they have committed a crime of moral turpitude, which also would impeach a witness in a court of law. Is that correct?
Mr. Chairman,
McDougal.
this is only felony crimes of moral turpitude, not misdemeanor crimes of
Correct.
moral turpitude.
That's right. It is a modest change.
Mr. Chairman, that was the question I was going to ask. Should we not be including all crimes of moral turpitude?
Well, and I guess I'd be inclined to come back next year with that, because I think we ought to keep, conform this provision to executors and administrators, and we probably ought to look at whether executors or administrators ought to be allowed to qualify if they've been convicted of a misdemeanor involving moral turpitude. I just think that they ought to be treated the same.
Anybody opposed to Senator Obenshain?
Mr. Chairman,
Anybody? Senator Lucas?
with the understanding that he's just trying to get conformity and is gonna come back next year to expand it, I move that we report this good bill.
Mr. Chair, I have a question. Is this being recommended by some group or something?
No organized group. It is a bill that had been brought to my attention by some folks who had concerns about some notaries who fall within these prohibited categories.
All right, we have a motion
It's already,
properly seconded to report
is
the
there
bill.
an event that happened?
Is there discussion on that?
There is not an event, however, at least that I'm aware of. However, there are grave concerns.
All right, please open the roll. Does that take care of you, Senator Obenshain?
It does.
14-0.
And I think we have to suspend. Do you have people here, John, on your bill? Your last bill? I think that's the last bill before the
Yeah, I
committee.
do have, there'll be some opposition.
You have people who came to,
Yeah, I think so. Let's find out.
What's the bill number, Senator Obenshain?
1708.
1708.
Yeah. Mr. Chairman, members of the committee, Senate Bill 1708, requested by the Police Benevolent Association. Right now, we have a law enforcement officers procedural guarantee act, but it doesn't have any teeth in it.
well, this gives it some big teeth.
Or no, it doesn't, not that much. What it does,
What this does is allows a panel to override the chief law enforcement officer in any.
right now, you're entitled to a panel,
but it's only advisory and should be, quote, accorded great significant weight, end quote, period. So you're right. You go through a panel, they agree, think you should be reinstated, and you can still be fired. What this does is say the panel decision shall be final and binding if consistent with law and written policy, and either party can go to court to have it implemented. So it does provide for real due process in the case of a law enforcement officer.
The administration support this bill?
I don't know. I doubt it.
How about
I'd like to have somebody speak in favor of it.
Well, how about the sheriffs? They support the bill?
I doubt it.
Doesn't apply.
Huh?
Does not apply to the sheriff's department.
Oh, it doesn't apply. Chiefs?
Chiefs have been silent.
Silent?
Yeah, I have not talked to Dana, but.
Come on, step up.
Thanks, sir.
Let's-
Mr. Chairman, members of the committee, my name is Sean McGowan. I'm the Executive Director for the Virginia Police Benevolent Association, and this is a bill we brought forward. Discussions about this bill started 10 years ago, and we've been working with it ever since. Substantial money, time, and effort is put into these processes by the grievant, the officer, by the lawyers, and the organizations such as mine that support these officers. With the expectation that when the panel rules, it'll be implemented. Now, most jurisdictions do implement the findings of the panel. It's not generally not a problem, but there's been more and more occasions where the panel is ignored. One of the things that came up, there's a county has come forward in opposition to this bill, and I just wanted to bring it to the panel's attention that under 15.2, 1507, that process is legally binding and enforced that way. That is the process that that particular jurisdiction uses. So they've come forward, and the draft language for this bill came directly from that law. So that jurisdiction is coming forward saying, this is how we do it, but we want to tell the rest of the state not to do it that way and do it another way. So I hope you take that into consideration when you are debating this bill.
Thank you, Sean.
Thanks, sir.
Mr. Chairman, members of the committee, my name is Kevin Carroll. I'm the legislative chairman for the Fraternal Order of Police of Virginia and immediate past president. I wish I could stand before you today and say that this bill is not necessary because every law enforcement agency within the Commonwealth would actually follow the process and do what's right. But in my 32 years of law enforcement and my involvement with the Fraternal Order of Police, I can tell you that's not the case. And I know of several grievances where the officers went through the process. The panel, which is chosen by one person by the officer, one person by the agency, and then those two people pick a person, ruled in the officer's favor, and they fired the officer anyway. And the officer ended up having to sue to get his job back. And there's a reason why law enforcement officers across the Commonwealth don't use this process when they're grieving something, because in their eyes, it's worthless when you go through the entire process and you're right back before the chief of police who says, I really don't care what the three-person judge panel said, we're going to throw it out. And so the FOP supports the legislation.
Okay, thank you, Kevin. State Police.
Mr. Chairman, Keenan Hook with the Department of State Police. We're concerned about this. We feel like it would open up the door potentially for us to be unable to deal with an employee who represented a danger to public safety. Most of our employees do currently go under DHRM's grievance procedure. We feel like that gives safeguards to everyone involved, including public safety, and this would take all discretion away and leave it in the hands of that three hearing officer panel to make an absolutely binding determination that could be flat wrong.
John, does this give any right of appeal to the chief law enforcement officer?
No, it's got to be final and binding, and either side can go to court to implement.
To implement it, but
yeah.
if the chief law enforcement officer says you're wrong and I've got compelling reasons, they have no recourse.
Well, it's got to be final and binding if consistent with law and written policy. Maybe there's something about the decision that's invalid.
Consistent.
I've
Well,
represented.
that's the procedural policy, isn't it?
This is, well, the new law would say it's final and binding if consistent with law and written policy. Maybe it's inconsistent with law and written policy, I don't know.
All right.
But that's the only out. I've represented state troopers in hearings where.
Senator Stewart.
Senator Edwards, Sean said this didn't apply to sheriffs, and I don't understand why, because it just clearly says law enforcement officer. The second witness said it applied to every law enforcement agency in the Commonwealth. Why does this not apply to sheriffs?
Charles?
I don't know. Some sheriffs do not deal law enforcement.
Yeah, under the definition of procedure guarantee, deputy sheriffs are exempt from the definition of law enforcement officer. So this doesn't, no procedure guarantee rights apply to any sheriff deputy in the state of Virginia.
Can't they?
My recollection
can't
is that's right.
They can't sign to be a part of it?
No, sir, no.
Okay.
My recollection is
Okay.
there are individual sheriff's offices who have voluntarily implemented.
Fairfax County for one, yes.
Right.
Yes, sir.
Yeah. Okay, the bill is before us.
Move to report.
It's been moved and seconded that the bill be reported. Oh, no, not to finance.
It'll have to go to finance, right?
It does not. I don't.
Ayes 6, no 6, abstentions 2.
Would you flip a coin in this case?
All right, bill fails to report.
Thank you.
All right, the committee will rise. Do we take care of everything?